We're going to go ahead and get started. Welcome to the December 1, 2016, almost Christmas time, land use meeting. I know, I'm excited. It's my favorite time of year. We will go ahead and start with the invocation. Dr. Pastor George Hefner. If you'd stand, please.
Quite a congregation.
Yes, it is.
I would like to suggest something this morning, that as I pray, have you all join with me in prayer for our nation, for our county commissioners. Folks, we are still one nation under God, according to our pledge. Let's do that as we enter into prayer this morning. Father in heaven, we come to you this morning, thanking you, first of all, for your goodness to us, thanking you for your Son, Jesus Christ. And then, Lord, for the privilege that we have as a free nation to come to you in prayer, seeking guidance and giving you praise. Lord, there is much that our nation needs today. There is much all the way from local government to federal government that needs your touch. And we pray, dear Lord, that you would intervene in behalf of each one. We pray especially this morning for our county. We pray for each of these leaders that are before us. Lord, that you would give guidance, that you would give wisdom in making right decisions. Lord, that you would draw us ever closer to you and help us to seek your perfect guidance. Lord, it is such a wonderful thing to have a God in heaven that's never made a mistake, and that everything that you do is right and good for us. Lord, may we seek to do the same. May we, again, seek your guidance. May you forgive us wherein we have failed you. But Lord, as we look forward to a new president-elect, we pray that you would work in his life, that you would give wisdom in making right decisions to draw our nation back to you. And then, Lord, as well for local government. Help each one this morning to seek your wisdom. Lord, that the wisdom of Solomon would be used in making decisions for the good of the people. We have people before us that are representatives of the people. May they not take that position lightly. But Lord, help us all be drawn ever closer to you. And I pray, dear God, that this day especially, that you would help those that are before the commissioners and the commissioners as well to behave themselves wisely and to seek your guidance and to seek your truth. In Jesus' name we pray, amen.
Amen.
Thank you.
I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Pastor, thank you so much. Thank you. I see that we now have Commissioner DeSabatino has joined us, so we're ready to get into the agenda. I would like to welcome this morning our two new commissioners. It's their first commission meeting. God bless you. Commissioner Trace and Commissioner Johnson. So it's nice to have you on board with us this morning.
Thank you.
All right, we will go ahead. I want to go ahead at this time, too, to do the Pledge of Public Conduct. We may disagree, but we will be respectful, keyword, respectful, of one another. We will direct all comments to issues, and we will avoid any personal attacks. That goes for not just you as citizens, but also for the members of this board. Also, at this time, if you would cut your cell phones or put them on mute or cut them off, that would be most appreciated, because sometimes we're in heavy conversation and it's a little distracting. What changes do we have to the agenda this morning?
Good morning,
Nicole?
Commissioners. We have several changes this morning. The first is Stonegate Preserve Street numbering waiver request. There's a revised map that reflects correct commissioners' names. The next item is an Amendment 1 to Development Agreement for a hotel in Palmetto. The agreement is attached. Item 12, PDMU 1605G. This is for Stonegate Preserve. There's a revised school report, revisions to environmental information section of the staff report, revisions to a stipulation E1, and revised ordinance to reflect the changes. Item number 13, PDMU 1612ZG. This is Lakewood Ranch Commerce Park. There's an additional stipulation E1 and revisions to the memo to reflect that. Item 14, Resolution R16116. This is a vacating a portion of an improved right-of-way at San Miguel Cove. There's revised resolution attached. Item 15, PDR 0414 PR3. This is regarding Riva Trace. There's additional public comments attached. And lastly, item number 17, Manatee County Pain Management Clinic Registration Ordinance, Ordinance 1644. There's a revised motion to continue the public hearing to January 5th, 2017. This concludes the changes.
All right, thank you, Nicole. Oh, moving right along. Let's see, we don't have any. We'll get into future agenda items. Each person will have 3 minutes to speak. This is just on future agenda items, and we take up to 30 minutes for that. So I have 2 cards here. We will start with Glenn Jubilina.
Good morning, Commissioners, and welcome to the 2 new Commissioners. My name is Glenn Gibolina. I'm a citizen and taxpayer of this county. Future agenda items. What I want to talk about, and I emailed all of the Commissioners today, that there is a property on the corner that is zoned, it's currently as ag. It is zoned for future use of heavy manufacturing and industrial. Now that backs up to my residential neighborhood. I don't think any heavy manufacturing or heavy industrial should back up. And I'll give you an example with Stay-Built, who we just had in EPA. Now, this is Stay-Built. This is my community. This is the proposed difference. Stay-Built. 9 years they've been there, creating dust and havoc in my neighborhood. Here's a report. They have no permit for sewer. They have no permit, has not even been applied for. There has been evidence of discharge of polluted runoff to the regulated running water. 9 years this has been going on. Where's the safety? Where's the safety in this? I don't see any. Outdoor air control, poor. Stormwater treatment, no. Dust control, no. Facility entrance, no. Everything I've been harping to this board for the last several years that we had this problem, and nothing has been done. We couldn't even get the driveway paved for this facility. So I have to go above your head because the county job can't do what they're supposed to do to protect its citizens. That's the problem I have with the government. Now, EPA has stepped in, and hopefully they'll get something done. There has been recommendations done. But again, 9 years. 9 years without a permit. How does it happen that they can pollute our runoff water for 9 years in the county, even though I've brought it up to several times over the last few years, doesn't see this. So I hope these guys really put the fire not only to Stay-Built, who has been disrupting my neighborhood for 9 years, hopefully give some direction to the building department and the safety welfare department of this county, which we have not been getting. So you all have this file. There's dust that blows over the walls. I'll let you read it. I'm out of time. Nothing gets done. I hope EPA does something, and I'll be back for Agenda 16.
Thank you, Mr. Jubilina. Linda Neely?
Good morning. And maybe there is hope in this county. Congratulations to the 2 new members of the board, to the Manatee County Commissioners, representing the people of Manatee County, the people. That is what government is supposed to be about, the people. Yet so many times it's the processes that our government agents seem to love it more dearly than the people. Just like Mr. Giubilini, I've been inundated with dust at my business due to my neighbor, that nothing appears to be going to be done about this situation. I know that contractors that are building housing developments next to existing houses water their pads, they water the raw roads they put in, so they don't create dust. We breathe and live dust almost daily on Whitfield Avenue. And nothing seems to be going to be done about it, period. I was promised that the gentleman would be watering the road to lay the dust down. I'm keeping a log. Believe me, it's 80% not and 20% kinda. But as to our public comments at this dais, I would beg you all to reread the Constitution of the United States of America and the Florida Constitution. It says that we have freedom of our speech to express our feelings, our beliefs, and the facts. And for this board to continue to demand that we treat you in a specific manner when from what we get at this side, Mr. Barnott said to me that I don't listen. That's why he doesn't communicate with me. He said he would not ever be alone with me again without witnesses. You know, yes, Carol's shaking her head. Yes, she saw that email. That is ridiculous because I tell the truth and the facts are the facts. And you earn our respect, you earn the ability to be likable, or if you earn our disrespect, then you earn it. So please remember, we have the right to say what we think, believe, and know to be fact. And we can use any words we want. Check the cases in the Supreme Court. There have been towns that paid out hundreds of thousands of dollars for actually removing citizens because they use swear words. Swear words are not illegal words. So the commission needs to take a broad stance. And I now understand Mr. Barnott, I think we need a public commission. He says you're going to go over every word in the dictionary, I guess, and define them for us because we people don't understand them. Thank you.
Wow. Is there anyone else from the public that would like to come forward on any future agenda item? All right, not seeing anyone, I'll go ahead and close public comment. Commissioner Whitmore?
Well, you know, I would ask staff, please, to, and I don't want to take a lot of staff time, but if somebody could research the issue with the runoff on that property that Mr. Giubilina is talking about, and if there is anything publicly that you can research just to see what EPA is looking at, I'd appreciate it, just so that we have our facts. And also, if our staff could find out, I guess whatever property he's talking about that's heavy industrial, when was that zoned? And, you know, you can't zone it just because the neighbors don't like it. You can't change the zoning, but how long has it been there? And it's adjacent to a heavy manufacturing now. So it's right next door to it, 5 feet from it. So I'd just like to know what the zoning is and when it was changed. I don't remember doing it since I've been up here. So we'll get our information. And also, Ms. Neely, we have never stopped anybody from saying whatever, and you, trust me, you say whatever you want up there, and everybody knows that, and you have every right to. Me as a commissioner would never talk to some people the way that we hear, that we're spoken to up here, and all we're doing, at least in my thing, is pleading for respect, because you can get the same thing done in a respectful way. And I will never do or talk to some the way that we are spoken to, and that's just not my style. And my mind closes off when I get talked to like that. I'm not going to work with you when, not you, but anyone, that when it's disrespectful. So I'm going to still maintain, ask, and I'm sure the board is too, to be respectful. When you're respectful, you work and you can roll your sleeves up and work and get things done together. So I would appreciate that, and that's all.
Commissioner DeSabatino?
Yeah, thank you. And the same thing, if Mr. Barnott and the team can either meet with me and go over what Mr. Jabalina and Ms. Neely, their concerns regarding their properties, because they're right in my district, especially the dust and the watering. I know we have that at another property that we're working with. And I just wanted to say big shout out to staff, I guess it was Public Works, who dredged the big ditches around Ms. Neely's property along Whitfield. So a long stretch. So I'm sure she's happy about that. Thank you.
And I'm next on the board. Mr. County Attorney, I hear the word Constitution being used. Sorry, Ms. Neely. I love the Constitution, and I know that I have a copy here in my office. I also have a copy at work, at home, and I take that very seriously. We are not here to break the Constitution. We're here to help endorse the Constitution. So, Mr. County Attorney, can you address that? Are we doing anything that's unconstitutional, to your
Madam Chair, the
knowledge?
advice of the office is that you are well within the bounds of the First Amendment and the protections of free speech in the Florida Constitution. It's well established in the case law. Legislative bodies have the right to maintain rules of civility and decorum,
Thank you.
so long as they do not stifle people expressing their opinions.
Right.
And we have reviewed those rules many times and are very comfortable that you are doing everything as you should be under the applicable
And
law.
I did want to ask you that question because I was upset with Ms. Neely, what she said. I just wanted to address that the fact is, we do have a pledge of public conduct. We stand by it here on this board, and so we just ask that others do that, because I don't think it's written from anything that I've ever read that your elected officials, you're given the right to abuse them. We're here to work with you to try and handle any problems that come up, and that's our job, and that's what we do, and we take that very seriously. And I just wanted to address that mainly for our
Glad you asked.
2 new commissioners. Commissioner Banat.
Yeah, and along those same lines, I just want to make sure when we're talking on a land use hearing, in a land use application, it's a quasi-judicial public hearing, and I wonder, we have to make sure that the comments are addressed in a land use hearing to the application that's before us.
Right.
And I know we had an issue with someone who was addressing other comments outside of the issue of a land use issue. It's a little bit different, and I wonder if I could get Attorney
that
Clegg
checked.
just to maybe comment on that, because this is our first land use hearing. And I think it's important that we understand the difference when you're in this quasi-judicial as opposed to future agenda items, which, are much more general. And obviously, a lot more can be said on on that portion of the agenda, rather than when we're in the actual land use application quasi-judicial situation.
Madam Chair, Commissioner Benak, I'll do the best I can to address that. Under the rules in quasi-judicial proceedings, we have a responsibility to act as a court would act. That's why we call it quasi-judicial. It's a fancy way of saying like court. Part of the responsibilities that come with that are making sure we're looking at relevant evidence to the matter that's before the board. So larger issues or issues unrelated to that matter really are not appropriate in that proceeding. That's why we have citizens' comments to bring up issues that aren't directly related to the matter that's being considered in the quasi-judicial hearing. It is critical from a legal standpoint to stay within the boundaries of those rules, because what happens is if we get challenged, and we can be challenged by somebody who's denied an approval, or we can be challenged by a third party who takes issue with the approval. We need a clean record. Everything gets typed up in a transcript and it gets filed with the court. And the court looks at it carefully, and they do scrutinize how we handle those issues. And that's why I've said before, the land use lawyers often act as sort of like the traffic cops in hearings, because we're trying to preserve the record for everyone's benefit, so that when it goes across the street, if there's a lawsuit, we can put it in front of the judge, and the judge is comfortable we handled things the way we were supposed to, and we weren't looking at issues that had no relevance to the decision we were making.
Thank you.
And on that note, the email that Mr. Jubilina referred to, by the way, I would say that I just happened by chance to see that email this morning. I was on the way here and I was stopped at a red light. So it's really best if you have questions about a meeting day that you get the email to us a little faster, because chances are we might not have seen it to be able to respond. But I did send it to the county attorney's office, to Bill Clegg, and also to John Barnott, to make sure that there was no application that had been filed, so that
That's
it would
correct.
be
There is not, to the
legal.
best of our knowledge.
right. Just wanted to mention that. Okay. We'll go ahead and move forward. Commissioners, do we have any items to be pulled from consent? Consent is items 4 through 10. Any items to be pulled? Yes, ma'am.
Would you like me to read them into the record?
Go ahead.
Okay. Item number
if you want.
4 is a reduction of code enforcement fines. Item number 5 is a reduction of code enforcement fines. Item 6 is an interlocal agreement with Manatee County Sheriff's Office regarding red light enforcement. Item 7 is Stonegate Preserve Street numbering waiver request. Item number 8 is an Amendment 1 to Development Agreement for a Hotel in Palmetto, Manatee County. Item number 9, Gatewood Corporate Center at Lakewood Ranch Land Exchange. And item number 10, execution of a HUD grant agreement for the fiscal year 2016-17 CDBG home and ESG grants.
All right, I have one commissioner on the board, Commissioner Benak.
Yeah, in relationship to item number 6, I don't need this pulled, but I will tell you I had concerns when I was briefed on this. This is the Manatee County Sheriff's Office Red Light Enforcement Agreement. We're extending that agreement for a period of 4 years because it's actually already expired. However, I have issues with the implementation of our red light camera agreement. I've been told by staff that this does not obligate us to continue this. This is an agreement that we can back out of, and that we have a workshop planned coming forward, because we have a lot of questions about red light cameras and how they're being, it's our contract with Xerox, is it, I think, is, or whoever the,
Vendor.
the concessionaire, whatever you call it, the person that is, that our contract's with for the red light cameras. So I have lots of questions about that. So I'll go ahead and let this go forward, because they're actually doing the work today without having us have this under agreement. And so I don't have a problem with that. I guess the agreement actually expired this last January. So I don't have a problem with that, but moving forward, there's still going to be lots of questions in my mind when we get to the workshop to talk about red light cameras.
I'm next on the board, and on that note, it's funny that I'm hearing you say that, because I did exactly the same thing. And it's my understanding as well that the execution of this agreement today will not in any way hinder us when we have our workshop to discontinue or change the way those services are rendered. So I feel exactly the same. Are there any other items to be pulled or any comments from commissioners? Commissioner DeSabatino.
Shout out to Sergeant Kenyon, who's there and keeping us safe on our highways. Appreciate him stopping in. Also, item 10, just a recognition for Denise Thomas and her staff for all the hard work they do putting this together.
Oh, there she is.
All the contracts and everything are just an inordinate amount of time involved with this. And we always have so many applicants that are wonderful and special and needy, and it's just so difficult to, decipher through all of them and get to the ones that are the most critical and the most in need. So we really appreciate all our hard work and dedication to these programs and keeping us in the loop and making sure we continue to get these grants. Thank you.
All right, I don't have anyone else on the board, so what is the pleasure of the board?
Public
We have
comment?
public comment?
Thought I did that already.
No.
We did on.
All right, we'll open to public comment on
I get to be
consent
chatty. You
agenda.
have to open up it for.
Oh, please.
I said it too.
You know, I just told, so you'll know, Commissioner DiSabatino is, I guess you'd have to say, she moved up to the first vice chair because Commissioner Chappie, of course, was first vice chair and he's no longer here.
you.
So,
So I get
Oh,
to be a
boy.
thorn in your side
Me and
for
you.
at least a month and a half, right?
are you trying to insinuate you haven't been in the past? She's my friend. I've known her for years. That was a joke.
That was good.
It was a joke.
Was good. I liked it.
Go ahead and open consent agenda to the public. Is anyone would like to come forward on any item on the consent agenda? Not seeing anyone?
No, Miss,
Oh, I'm sorry. That's okay. I think I was still thinking about Robin. Sorry. Lori, come on up.
she's in the district. so.
Good morning, my name is Lori Gale, and I'm a citizen of Manatee County. Boy, that was quick.
That was quick.
Robin, see what you did?
Shorten your name.
See if you get another candy bar. No more. My question is regarding workshops, which was brought up this morning. You're going to be having a workshop on the red light cameras, about getting them televised also. It would be great to be able to see them and know what's going on for those people who are not here, and I'd just like to know about getting those opened up to the public. Thank you.
You're welcome.
Good idea.
Anyone else want to come forward on consent? All right, Robin, closing it.
Good.
All right, we'll go ahead and close public comment.
Motion to approve the consent
Well,
agenda.
wait a minute. I do want to make a comment on what Lori asked about TV cameras on workshops. Funny you'd mention that, and please let everyone know I did not discuss that item with you. But it's funny you'd say it, because I actually have tried to do that this year as being chair. I've mentioned it a few times, that I thought it would be a good idea to have it televised for the public, because it's not always convenient for the public to be here for all of our workshops. So perhaps the new chair, as of in January, might be more successful on that endeavor than I have been, but I do agree. Just wanted to say that. Yes, ma'am.
Ditto. Actually, we did have that conversation over lunch one day, and she came up with the idea, and I thought that was great because there's so many important things that go on at workshops. And actually, I'd like to go back and be able to rewatch them myself.
Too.
And so I think that it just takes 4 people from this board to make it happen. So maybe we can discuss that at a later date or this afternoon. Motion to approve consent.
Second. We have a motion to approve by Commissioner DiSabatino, a second by Commissioner Johnson. Sorry,
Aye.
Betsy, I'll have to go with him on this one. All in favor, say aye.
Aye.
All opposed, nay. It is approved 6-0. Thank you. Actually, 6. There's only 6 of us here. So we'll go into, moving right along. Advertised public hearings. Nicole, number 11.
the clerk
Yeah, we
to
need
swear
to do
people in?
Bless you. Not contagious, sorry.
Sorry?
Not contagious.
Anyone who might speak.
Yeah, if anyone intends to speak, please stand up and be sworn.
It's free, even if you don't use it.
Do you swear or affirm that the factual statements and factual representations which you're about to present to this board will be truthful and accurate? I do. Thank you.
Thank you. I had to get my coffee. Nicole, go ahead, please.
The first advertised public hearing is item number 11, LDA 1302R. This is Parish Holdings LLC, Southern Land Parish LLC, Southern Hemisphere Manatee LLC, North Manatee Investment LLC, the Villages of Amazon South LDA Agreement. This is a request for approval of an amendment to the existing local development agreement. And this is the second of 2 hearings required, the first being held November 15th, 2016.
Thank you, Nicole. And this is a quasi-judicial item. So I will go ahead and ask if there's been any ex parte communication from board members. All right, not seeing any. We will go ahead. And this is strictly, correct me, the second public hearing on this, right, Nicole? I'm sorry.
Correct.
Okay. Well, all right. Who is handling this for staff? Anybody?
Do we want
Clark,
to,
you want to say anything, or can we just,
presentations now?
yeah?
It's a short intro.
Yes, we introduced this topic to County Commission. For the record, Clark Davis, Transportation Planning Division Manager, and I have been sworn. This is an amendment to an existing local development agreement. We introduced this topic to the board a couple of weeks ago. At this hearing, we would ask the board consider adoption of the agreement. Nothing's come up that changes our staff report or any other thing included in the agreement, so I don't have anything else to add to the record at this point, but I could answer any questions that you have.
Here we go. Commissioner Benet.
Yeah, and just for clarification, the only real change here is an extension of time because nothing has moved forward yet. Is that correct on this?
Yes, the agreement covers some transportation and wastewater improvements. They were to construct a sewer line extension by December of this year. They've asked for an additional year to complete that work.
Okay, thank you.
All right, not seeing anyone else on the board, I will open this to public comment. Would anyone from the public like to come forward and speak on this issue? Not seeing anyone, we will close public comment. What is the pleasure of the board?
I move to recommend the recommended motion.
Second.
All right, we have a, by Commissioner Whitmore, a second by Commissioner Trace. I'm losing my voice. All in favor, say aye.
Aye.
All opposed, nay. It is unanimous. Thank you. I'm dying over here.
You need an
I
cough
know.
drop?
I've got some.
Okay.
All right, Nicole.
The next item on presentations upon request is item number 12. This is PDMU 1605G, WSI Land Holdings LLC, Stonegate Preserve. It's a general development plan for a mixed-use project consisting of 791 residential units, a community center, and a private school or daycare on approximately 415 acres on the south side of Buckeye Road and west of I-75.
Oops. Did you just get back on the board?
I did.
Excuse me. All right, this is also quasi-judicial. Has there been any ex parte communication?
Nope.
No, not seeing any. We're on a roll today. All right. It is presentation upon request. Does anyone need a presentation? The two new commissioners?
Not I.
On the board.
Okay. All right, Commissioner Whitmore?
I would just like staff to confirm that this is, very shortly, because I don't need a presentation, Brandon, just exactly what we're doing. It's what we did in 2012, but just to confirm that so everybody knows that this has been before us a long time ago.
Absolutely. Good morning, Commissioners. My name is Brendan Rowe. I'm the case planner assigned to the project with Building Development Services. I've also been sworn. You're correct, Commissioner. This project came before you way back in actually 2005. It was approved. During the recession, during the economic downturn, the project went through the process of getting its PSP approved before the board, as well as a final site plan approved administratively. Both of those approvals expired during the recession. The applicant today is coming forward to seek approval of the exact same entitlements that were previously approved. No increase in density, no increase in intensity, all the same uses. Essentially, it's just reinstating what was previously approved. They just have to go through the process because it died.
Thank you.
No problem.
Commissioner Benek?
Yeah, and Brandon, during my briefing, I had a question about the noise stipulation because did it change? Did the noise stipulation change from what we saw previously to what's proposed today?
It did. I had a noise stipulation that was older version of our standard stipulation. It's been revised. That's in the update memo that you received.
Great, thank you.
So that's the more detailed one. Yes,
Okay,
ma'am.
just let everyone know, because this is along the interstate, it had a very, what I thought was kind of a weak stipulation on the noise. And as we know, as developments are developed along the interstate, we hear from people if they have noise issues. So we want to make sure that the developer is required to put in the noise mitigation And so this stipulation did look different, so that's what we're using today to require that they mitigate for the noise of the eventual build-out of I-75. Is that correct?
Yes, ma'am.
Okay, thank you. That's better.
Commissioner Trace.
Once again, as we move forward with this, so we have extreme roads, traffic, stormwater issues at that area. There is no way to get there or leave too much. So as we proceed forward with this, we're going to definitely have to make sure that all of those things are taken care of. But the sounds definitely, the interstate's a problem. So thank you for bringing that up, Betsy.
Commissioner DeSabatino.
Yes, and I had also had some questions at the briefing, and I appreciate you answering them about the UMAM scores and so forth. And also, I just wanted to go on the record that there's inter-neighborhood connectivity and into Artisan Lakes. We had asked to reduce the roadway buffer off of Buckeye, but then there's a 100-foot gas line. So I didn't have any problem reducing that because you already have the 100 feet. And the wetland setback, I'm comfortable with. And just, I'm glad you brought it to the attention that they're going to have to do a noise study at final site plan. Traffic analysis will be required. A couple of the schools don't have capacity, so that will be addressed at the final site plan. So thank you for addressing all my concerns.
My pleasure.
All right, I don't have any more commissioners on the board, so at this time, we'll open to public comment. Is there anyone from the public that would like to come forward and speak on this item? Not seeing anyone, we will close public comment. What is the,
District Commissioner? Move to approve the recommended item.
thank you. Is there a second?
Second.
Commissioner Whitmore made the motion with a second by Commissioner DeSabatino. All in favor, say aye.
Aye.
Opposed, nay. It is approved 6-0. Moving right along. Nicole, go ahead.
Yes, item number 13, which is also on presentations upon request. PDMU 1612ZG. This is Lakewood Ranch Commerce Park LLC, Lorraine Corners Northeast.
What?
This is a rezone of approximately 68 acres generally located on the north side of State Road 70, east and south of 59th Avenue east of Lorraine Road and west of Post Boulevard, from general agricultural to planned development mixed use. It includes a general development plan for a mixed-use project including a maximum of 220 residential units, a maximum of 573,500 square feet of non-residential use or a combination of residential, commercial, and office use not to exceed the maximum thresholds of a combined project, and approving a schedule of uses as voluntarily proffered by the applicant and is attached as Exhibit B.
All right. This is also quasi-judicial. Has there been any ex parte? No? All right, we'll move forward. If we could just get a little bit more in a presentation for the public, that would be great. Who would take care of that for us?
Good morning, Commissioners. Margaret Tusing with Building and Development Services, and I have been sworn. Do you want a formal presentation or
No,
just?
just,
Okay.
Just so the public understands exactly what might be going on here.
Okay. This is a rezoning to planned development mixed use for a mixed-use project that could contain up to 220 residential units or 537,000 approximately square feet of office and commercial. It is part of the Lakewood Ranch area, and the area that's surrounding it is mixed use. There's on the north side of 59th are institutional type uses, churches, fire station, Peace River Electric, the post office, and this is over by Premier Sports. So it seems an appropriate use to have the commercial office uses. And the residential uses, I believe Commissioner Benak had asked to include a stipulation, which we have done, that if the northwest corner develops with residential uses, that, the notice to buyer includes information regarding the location of the Premier Sports, that it's an active recreational area, and then also that commercial and office uses are approved for this adjacent development, and there would be no further board hearing on any of those items.
All right, thank you. Commissioner Benak?
Yeah, I appreciate that, and I'm sure Commissioner Baugh is well aware that at Premier Sports, they sometimes have evening events. Sometimes, there's noise concerns over there, so I wanted to make sure that, like the folks who live by IMG, they know that they're going to be near an active recreational area that probably does use, a PA system. I don't live over there, but I have been to a concert over there, so I know that they do have sometimes loud events. So anyone that is being proposed in a new residential subdivision needs to be aware that they're in proximity to such, a place that holds such events. So I appreciate you putting that stipulation in. So that's the intent. And of course, we also have in our noise ordinance a specific kind of exclusion, if you will, for sporting events, right? That Premier Sports would come under that specific exclusion. So I guess it's kind of a buyer beware if you're going to live in a home nearby this sporting facility. And I guess it's what we figured it out. It was like 3/4 of a mile
Yes,
away.
ma'am.
So that's not terribly far when it comes to noise.
No, and to add to what you're saying, I think Premier has been very fortunate with all the events that they've had since they've opened. I can only recall truly one time when we received I received a few phone calls in reference to the noise, and Premier quickly turned things around to get it further away as much as they possibly could from the residential areas. So they definitely have that in mind and know that the sound is an issue. So that's why I'm not too overly concerned. I think they will handle that quite well. Commissioner DiSabatino.
I just have a question regarding along 70 on the roadway, and is there going to be sidewalks stipulated, or is there enough right-of-way in case for further expansion?
There's sidewalks already there.
The sidewalks there? Okay.
The stipulation is for Lorraine Road. There's a stipulation already
Okay.
in there that they will either, Lorraine?
70.
Oh, I'm sorry,
70.
70.
Yeah.
They will either construct the sidewalks and/or pay into the fund.
Yeah. Yes, Tom.
Mr. Chair, excuse me.
Mr. Chair?
Madam Chair, excuse me,
Feel different.
Madam Chair. For the record, Thomas Gerstenberger, Public Works Department, I've been sworn. Just to reiterate what I was shouting out to Margaret there. The stipulation, which is stipulation D5, is with respect to State Road 70 and offers the applicant the option to either construct the sidewalk on State Road 70 or to provide a payment in lieu of construction for the sidewalk along State Road 70. With respect to State Road 70 itself, there is a DOT project. There is right-of-way acquisition, and the next couple of years, that is programmed for the widening of State Road 70, and then following that acquisition would be construction in further out years.
Okay, thank you.
Could I just,
And go ahead.
Tom, could you just clarify for the record, we're talking about the sidewalk along the project frontage?
By Premier.
Mr. Clegg, that is correct. That
Excellent.
would be the sidewalk along the frontage of the project and State Road 70.
Okay, thank you.
Because there is already a sidewalk in the residential areas down to, if I'm not mistaken, Lorraine Road,
Within,
residential side.
yes, within Greenbrook itself, yes, there is sidewalks that are
Yeah.
already in place.
And if I could also add on State Road 70, talking about the traffic improvements that will be made, also DOT is doing a PD&E and a design as we speak to widen State Road 70 to 4 lanes from Lorraine down to 675. So it's moving right along. Hopefully they'll have money for construction after all that, hopefully.
Another speedway.
Yeah, exactly.
But then they'll have the roundabout to stop
Well, that's
it.
what I was going to say. Yeah, probably,
Or
I
speed
know, I'm
bumps.
waiting
I'm
to hear about
sorry.
some roundabouts. Yeah, shouldn't say that too loud.
I'm sorry.
All right, I don't have anyone else on the board. Is there anyone from the public that would like to come forward and speak on this item? Mr. Bedford, I see you back there. You have anything to add, sir? All right. Not seeing anyone from the public, we will go ahead and close public comment. I would mention to commissioners that there is a revised motion. If anyone's ready to make that.
So made.
All
So
right.
made. Good.
So made.
Good, Steve.
We have a revised motion by Commissioner Johnson. Is there a second?
Second.
Second by Commissioner Whitmore. All in favor, say aye.
Aye.
All opposed, nay. It is approved 6-0. Thank you. I like that.
Efficient.
It works, whatever works. Nicole?
The next item on the agenda is item 14. This is Resolution R-16-116, vacating a portion of improved right-of-way at San Miguel Cove.
Okay, and we're going to, there's actually two items on this, but we're going to do item 14 first. And then we'll open 15. Is that correct?
Madam Chair, that is the recommendation of the office. I talked about it with Mr. Palmer this morning, and because the items are interrelated, but they deal with different issues, different testimony, different legal standards, and so we think it's best to handle them sequentially.
So I guess we need a full hearing.
We probably need a full hearing on this, yes.
Could I just make a couple of brief statements about the
Sure.
standards for this is a legislative item. So this is a matter of the board's discretion to determine whether or not the petition to vacate the right-of-way is or is not in the public interest. So it is different from the rezoning that is scheduled to follow it, which is quasi-judicial and governed by a very different legal standard.
Gotcha. Okay. All right, yes, sir.
Good morning, Commissioners. My name is Tim Christella, Real Property Specialist, Property Management, and I have been sworn. This vacation application was continued on August 4th to be heard on September 1st. Unfortunately, Hurricane Hermione canceled the meeting. The applicant, Mandarin Development, Inc., is requesting a vacation of 600 square feet, which is approximately 40 by 15, of improved platted right-of-way, known as San Miguel Cove, that currently provides emergency and secondary means of access. The applicant has also submitted an application to amend the access points for Riviera Trace subdivision, and this application will also be heard on today's agenda. This vacation is to eliminate an emergency inter-neighborhood connection between Riviera Trace and Carriage Run subdivisions. The vacation would allow Riviera Trace to eliminate the expense of maintaining a remote-operated access gate. Jurisdictional reviews by appropriate county departments and private utility companies serving the location to be vacated have been notified of the intention to file a vacation. Public Safety, as of July 7, 2016, supports the vacation based on an actual site inspection by the Emergency Medical Services Chief and the Public Safety Department. They feel the width and the layout of the roadway alleviates the need for a secondary means of access. Building and Development Service supports the vacation because the two departments who were recommending denial are now recommending approval. The Fire Department position is no objection and is based on recommendations from staff. An email dated July 26, 2016, between Leslie Aden, Fire Marshal, and Tom Gerstenberger. Property Acquisition received this email August 29th and supersedes the Fire Department's amended review dated 11/3/2015. A permanent easement is required and has been executed by Mandarin Development and will be presented to the board if the vacation is approved on a consent agenda. The permanent utilities easement addresses the concerns noted by Public Works Department during the jurisdictional review process. The applicant, Scott Rudisill of Blaylock Walters, is also here, legal counsel, to answer any questions as well as me. That concludes.
Thank you. I don't have anyone on the board, so I'm going to go ahead and start. I have several questions on this issue.
Presentation.
Hear from the applicant?
Well,
Some kind of concern.
go ahead. All right, I'll wait. Does the applicant have anything they would like to add?
Good morning, Commissioners. For the record, Scott Rudisill here on behalf of the applicant. I'll just cede the floor to answer any questions that you have, Commissioner.
Well, I know that we need to look at this one before we do the rezone, obviously, but, you know, it kind of, in my mind, it all goes together, and I'm curious as to why It is changing from when the homes were first built, when the subdivisions were first built. And if you could, Scott, if you could tell me the year, because I know it was done, I think before I was on the board.
Sure.
So when were these homes built, thinking that there was going to be a gate between their neighborhoods?
Well, let's start with, the Riva Trace project was approved in 2012. The original project was approved back in '04, but this developer brought forth the Riva Trace approval in 2012. But the developer came back to the county commission immediately after that hearing and said, we want to eliminate this gate in this location. And it's essentially been working for more than 4 years to get this issue back before the board. So I don't think there was any period where it was anticipated that that gate would remain, at least from the developer's standpoint.
Developer side.
Correct.
And if you could help me, I know you said it was started in '04. How many homes were built when the new developer took over the area? How many homes were already there?
No, I don't think
The
there were.
reason I'm asking, you don't think there were any
I
there?
don't think there were any there.
In one year?
Did they say what year?
It wasn't platted until just within the last couple of years.
You're talking about Riva Trace?
Riva Trace.
All right, but how about,
But
and,
University Place was there.
thank you.
Mhm.
And what was, do you know approximately when that was started and how many homes might have been there thinking that that gate was going to be there?
Oh,
I'm
well,
trying to get the history because
sure. I mean, University
Gotten a lot of
Place was
emails.
pre-existing, and they had always opposed that access point. Even during the public hearings for Riva Trace, the adjacent community was opposed to that access point. The only reason it was provided is because, as you know, back then, every inter-neighborhood tie was connected, even though you had two communities that were going to be gated.
I was just curious as to what your thoughts, and then I'll have some questions for staff
Sure.
when we get to that point. Thank you, Scott. Commissioner Trace, did you?
As a person that kind of grew up with being able to say, God willing, and the creek don't rise, because when I grew up, if the creek rose, we didn't go. We literally had a problem, and if we'd have had an emergency, we'd have had a problem. And so I'm kind of opposed to this. I think it's a long way back, and I think the citizens 10 years down the road, if a backhoe hits a main road, knocks that road out, that's a long walk to those homes back there. To have a gated second entrance, it's there for emergency purposes, I just have kind of a problem with vacating it. And I think that the engineer 10 years down the road might come back and say, I told you so, as we're trying to put a temporary road to get those folks back there, and they're down here hollering at the next commissioners.
I like that part. Commissioner Benak?
Yeah, this has been going on a long time, but I do have some questions for staff.
Do too.
The 800-foot cul-de-sac rule. My understanding, there's variance. I mean, that is created by what standard, the 800-foot cul-de-sac rule? That we have in our code, which I think everybody knows. We have a rule that says cul-de-sacs shall generally not be more than 800 feet, but I'm pretty sure we've deviated from that rule in the past. If you could comment to that as well.
Madam Chair, Commissioner Benak, the specific requirement for cul-de-sacs is within section 1001.4.d.1 of the Land Development Code, and it reads, cul-de-sacs and dead-end streets shall be limited to a maximum length of 800 feet, and any new development shall be constructed to Manatee County Public Works standards. With respect to any type of deviation from that particular standard, that would typically be done through a specific approval request.
Okay, so it's been done before. I think Sarasota County has, some counties have, and maybe Clark might know this off the top of his head because he worked there. I think they had like 1,100 feet or something. It was something different than 800 feet. I don't remember. Maybe it was less. Do you know off the top of your head?
I don't recall, but it was somewhere in the same ballpark, the 800, 1,200 foot range.
1,200 foot or something. I do recall that it was, so that is a standard that we utilize. And that was, I assume, because I wasn't here, that was the main reason for having this connection plus. and I was going to ask this about University Place, presumably University Places was an inter-neighborhood tie. They didn't have a cul-de-sac issue linked, or did they?
Commissioner Benek, that, first off, the street that leads up to the boundary with Riva Trace was designed and provided as an inter-neighborhood tie. And to answer the other question, no, there was no specific instance in this particular case with Meeting Street that the cul-de-sac or that the street itself exceeded 800 feet.
Okay.
There is, and one other point to make, there is no turnaround or cul-de-sac at the end of Meeting Street along the northern boundary of University Place.
Right, right. It was just proposed there as an inter-neighborhood tie, which, of course, our land development code encourages inter-neighborhood ties to keep people off of thoroughfare roads in case they're going back and forth to visit neighbors. And I did want to ask a question about the floodplain issue, because we have information that shows this was all in a pre-development floodplain, and subsequent to development, there was a map amendment so that the lots are not in the floodplain, not in the 100-year floodplain. Is that correct?
Commissioner Benek, that is correct. Pre-development and associated with the permitting of this project, portions of the project are within the FEMA flood insurance rate map 100-year floodplain. Subsequent to the construction of this project, the applicant filed an application for a letter of map revision through FEMA and effectively pulled out the lots out of the 100-year floodplain.
Okay. The portion of Rio Bella Place that crosses over I'll call it a tributary, I don't know, a wetland, an arm that extends to the Braden River, is that still in the 100-year floodplain? Where the road crosses over that tributary arm, whatever? I assume there's some sort of a culvert under the road at that point?
Commissioner, to reiterate again, the letter of map revision was only for the lots themselves. It would not have been for the infrastructure associated with the subdivision. The street network, the culvert crossing itself, during design and permitting, was constructed for a 100-year storm event.
Okay. And I want to ask a question, because I discussed this a bit in my briefing, and I want to make sure, because these are two related applications, and the instance of having less than 100 units could allow for having only one means of access. That's what our code says. And the folks here, not here, the people we've been hearing from seem to be very divided on this issue. Some thinks it's desperately important to keep this access. Other thinks, if this had been from the beginning, this access might not have been required, because you go in, you develop, you fill, you do these things, and you're no longer in the 100-year floodplain. You don't have the safety issue. What seems to make sense to me is that perhaps the access point could be cut off, removed, landscaped, but not vacated. Because that gives the HOA down the road the chance, because we don't know what the future holds. And I think we have instances in Manatee County where we have platted rights-of-ways that aren't built. I know it's a little unusual because this one's built. But we have instances of platted rights-of-way that are not built. It allows for the future potential connection, but doesn't have a road going through it. And to me, I may be splitting hairs here, but I'm trying to figure out the best solution for these folks. And I don't see why we have to vacate first without considering removing changing the stipulations as proposed by staff to require that it be landscaped and that the buffer be built, but not necessarily do the vacation. But that's mine from a policy directive. I see that as being perhaps a good idea, but I don't want to run into some, and maybe we could hear from the applicant if they would be object to that.
I think the county attorney's office has weighed in on that issue. That was actually what we had proposed originally.
No.
But the direction we got from the county attorney's office was that the road needed to be vacated, that you couldn't have couldn't take the access point off your site plan while it was still shown on the subdivision plat, I think was the determination there.
Patiently waiting over here for my turn.
You can take your turn.
Madam Chair, Commissioner Benak, the first problem is that is our right-of-way right now. So they don't own the property anymore. They've basically, please let me finish. They have dedicated a right-of-way over that portion of the site plan. So unless the board grants the petition to vacate, there isn't jurisdiction for the county to approve a request from them to change the use of that land. It remains our right-of-way. It's up to us to decide whether or not we want to open it or not open it if we decide to remove the condition from their site plan later that requires them to put a gate there.
Okay, well, then
That-
that
I hope
is
that-
different than what I was told in my briefing.
Well,
Because
I'm
I
not-
specifically asked about the right-of-way, who owned the right-of-way, and was confusing, and I know where Sarah's not here. She and I had this discussion, and Nicole, you remember, that this is a private road, is not county right-of-way. Even that's what I was told. So if that's not true, then that's different information than what I was told.
I'm very familiar with this plat because we've been in court over this plat. So I understand what you're saying. We have litigated this plat very recently. So, and maybe I phrased that the wrong way. It is, when a right-of-way is dedicated, well, maybe Scott can clarify. Is there a dedication of this right-of-way to the public?
No, it's a private
It
roadway.
remains private. Okay, well, then I misspoke. I'm sorry, I misunderstood that. So, because I know a lot of the areas in there are dedicated to the public.
It is confusing because
Yeah, it
Sarah and
is
I
very
had a big
confusing.
discussion about this, and Nicole,
Yeah.
you remember, in my briefing,
Yeah.
because of the way the documents in the plat read, it says right on the plat that it is private land, but the documents imply that it was dedicated. So it is very confusing.
Yeah, it has to be because, well, let's just leave it at that. I think we should proceed.
But to get to the heart of your question, certainly in the future, the association could provide that right-of-way back into dedicated form or reopen that roadway. They would always have that ability down the road.
Well, that's what I was trying to, I guess, hedge my bets, so I'm gonna hear from the public.
Sure.
But that's just from what I've heard so far. I was just trying to split the baby, maybe can't do that, but, I'm open-minded, so hear from the public.
Commissioner DiSabatino.
I have some questions, and I don't know if it'll be later or now, but it was just confusing when you said that there were no houses, and this was all in 2012. I mean, I remember sitting basically where Mr. Palmer just was back before I was on this board, that they were discussing this very same issue till 8 o'clock at night, and the issue regarding the 800-foot cul-de-sac was the order of the day, and that emergency gate was because of the 800-foot, not because of 87 homes, which was less than the 100 that you only needed the one entrance. So that's been on there since day one. So everyone who has bought since then has been under the impression that that emergency gate will remain because of the, okay, so I'm just bringing it up because.
University Place. Riva Trace.
Riva
Trace
Trace.
too? You guys
Okay.
weren't here when I came in.
Madam
Okay.
Chair, we do need to try to maintain a certain level of, it's not quasi-judicial, but we shouldn't be
So
having a
that's why
shout.
it's very confusing, so I would like to, maybe get more of a presentation of leading up to this, because it's just very, very confusing.
Madam Chair, just to go back to Commissioner Benak's question, Ms. D'Agostino is here, and she can clarify the status of the right-of-way and why it's come before you as a petition to vacate. It is private right-of-way. but the statute authorizes us to consider that through a petition to vacate process. So I did misspeak when I said it was right-of-way that we owned.
That we owned.
So Pam, do you want to just briefly clarify that?
I can just cite to the statute. Pamela DiAgostino from the County Attorney's Office. Statute we're operating under is 336.09, and under subpart A, it specifically says, I'll read the beginning so that leads up, the commissioners, with respect to property, under their control, may in their own discretion, and are authorized and empowered to, and then subsection A says vacate, abandon, discontinue, and close any existing public or private street, alleyway, road, highway, and other place for travel. So even if it's a private roadway, because it's supposed to be used by the public in that private capacity, you still have the authority to vacate.
Thank you. Anything else, Bill?
But not the mandate?
Well, you don't have a mandate to do it. No, the only thing I would add to that is that under Florida law, when you buy a lot of record in a plat, the courts say you buy in reliance on that plat. It is the ultimate notice to buyers. There are many things that can't be changed in a plat once lots have been sold off to individuals without the consent of all of the homeowners or property owners in that plat. There is an exception for right-of-way under the statutes that Pam just cited that allows the board to make that decision with or without the consent of everyone in the plat. So that's why rights-of-way come to you a little differently than other changes to a platted subdivision. But it is still your discretion, legislative discretion, to decide whether or not to grant that request.
Sorry. Commissioner Whitmore?
Well, okay, I'd like public safety to come down, because I've been here with a lot of it, and I think I was at those meetings till 8 o'clock at night in the past, and it just doesn't pass the smell test to me. First of all, we forced them to make the tie, and that was, I know that was Ron Getman's thing years ago, and we had inter-neighborhood ties, and it all made great sense, but nobody, I mean,
Still
and
in our
then now
code.
now we actually don't do it anymore.
No, it's in our code still. Right,
But
Nicole?
we give exceptions, yeah, we're not, okay. So, and I understand this has less than 100 homes, so you really didn't even require, that. But then we got the 800-foot rule, and no matter either way that I looked at it, was over 1,000 feet to get in and out. As a nurse, if we're not gonna do, and it's because the cost of the gate, I can't believe the cost of the gate costs that much that we would even be here today, because they're all over. I mean, I hear it's because of the cost. Why don't you just leave it open then? I just couldn't, I mean, why even have a gate there? Why do you have, you're not allowed
please.
to talk, please.
Public comment will come
Yeah,
up.
under public comment, but, if you're gonna have, this has been talked to ad nauseum. And I've always relied on public safety. And I talked to staff the other day, and to get to some of the homes, it's quite a trip. So why did all of a sudden you all change your minds? Because of the width of the roads doesn't mean nothing to me. You still got to go around. So I don't understand how that happened. And I'm not, you know me, I'm not critical. I just want to know why, because I'm,
No, and it's a good question. There's a
Buddy.
couple of points in there. First, the one biggest point that needs to be clarified is public safety doesn't care if there's a gate or not.
right.
All we want is if there is a gate, that the gate meets county ordinance that requires a remote access for fire, EMS, and law enforcement to get through the gate using our remote controls that we have in place across the county.
Mr. Smith, I'm
Yes,
sorry
ma'am.
to interrupt you, but you need to let the clerk have your name, sir.
Oh, I'm sorry. Bob Smith, Director of Public Safety, and I have been sworn. My apologies. So again, it doesn't matter to us whether there's a gate there or not. If there is a gate, however, it obviously needs to comply with county ordinance. when public safety looks at these types of situations, and as Commissioner Benak pointed out previously, there have been variances in the past. When we look at these, we look at them from a couple of different perspectives, and most of that has to do with getting a vehicle in. And our number one most common challenge in streets and cul-de-sacs of this type is the width of the road. And what we run into most commonly is in residential areas where residents park on the street versus in their driveway. And you'll have resident here with the car in the street, and across the street, there's a resident with their car in the street, and it closes the street down. Our ambulances are about 12 feet wide. Fire trucks are a little bit wider than that. So if that happens, we can't get through. And so for that, one of the things we did was we went out and physically inspected the site right after this came before the board in August to see what the actual site looks like now. And what we determined is if there is a car parked on the street on both sides, we still have plenty of room to get a fire truck or an ambulance down the street. That doesn't block us. The other issue we run into on the length of the cul-de-sac is if for some reason we had to back an ambulance or a fire truck out, specifically an ambulance out, especially after you have a patient on board, it takes longer. You would have to back an ambulance out if the ambulances can't turn around. And obviously, in this case, there is a turnaround, and then there is the cul-de-sac at the end that does allow, and a turnaround point that allows the ambulance to turn around and come back out versus having to back out slowly, obviously, to get a patient out. So those are the two biggest things that we looked at when we did the site inspection that led us, after the August board meeting, to determine that we would have no objection to this.
Okay, then I'd like to ask Scott a question. Scott, what is the issue with the cost of the gate? That I don't get.
I don't either.
Well, Commissioner, I'd like to hit on both issues if I
Okay.
could, because I'm going to start with a follow-up on Bob's comments, and I think 3 commissioners asked about the 800-foot issue.
Yeah.
The 800-foot issue has never been about the access to the, to the number of units. The 800-foot issue has always been about turnaround locations. And so that's why you'll see, if you look at this, the site plan approval here, that there's a turnaround point at the intersection midway, and then they were required to put in the cul-de-sac towards the end because it was at approximately 800 feet. And if you look at the language in the prior approval, when it talks about why the specific approval was granted, and it references section 907.9.4.2, which is the cul-de-sac length, what it says, it's been satisfied because vehicles can turn around without going to the end of the road. So that has never been an issue with the second access point. The second access point, as Bob said, was about the roadway width issue, which was a separate specific approval, and that's been addressed. So this has been kind of a red herring throughout this process. As to the cost, the developer's been working on this for 4 years. It has certainly cost much more
The gate.
than that gate would ever cost to go in.
I know.
But this particular developer, when they see things that don't make sense, are willing to go to that cost to bring it forward to have the discussion. Excuse me. So that's why we're here. We think it's a better project with landscaping and a gate, both from an aesthetic standpoint and from a security standpoint, and that's why we're still pursuing the application.
Okay, so I have a question. So,
Can you
you've
leave-
satisfied, what?
No, go ahead.
So you've satisfied our requirements because there, or the developer has, because there's another roundabout in there to be able to turn, correct? Bob and Scott, and you may want to come up. I just want to make sure, because my whole deal is public safety, and that's the reason why we had these rules in place, because of public safety. But public safety, were those 2 roundabouts there before?
I couldn't speak to that. I don't know if they
Scott?
were there or not.
Do you know if those 2 roundabouts were there before to be able to turn around? I'm calling them round, you know what I mean?
Yeah, they were provided, that's what I was saying. They were provided in order to justify the specific approval for the cul-de-sac length.
Well, then how come public safety denied it before then? Sorry, that's not.
No, that's probably not a question for me.
Obviously, the original denial from public safety came from previous management of the Public Safety Department. I couldn't speak to it. And so the length of the cul-de-sac, the turnarounds, the width of the street, I'm not sure that there was ever a physical on-site inspection done of the property by public safety. I could
So you
give
physically went out there and that's where you saw that?
We did.
It
We went
would
out,
work.
physically inspected the area, drove the streets, parked our trucks in areas we thought would be a problem, and we're fine with it.
And I respect that, because on other issues, I've heard that when things that citizens had concerns on, I know of a business person that actually went out to, on their own to see the concerns that the citizens had, and was shocked that they were right. So I'm glad to see that we did a on-site, and something like this, as contentious as this was, because I think I was here till 8 at night, I wish public safety would have gone out and looked at this, because that is the whole premise of why we've denied it before, because of public safety. Now, Betsy mentioned that we've approved these before throughout the county. I don't know who to talk to on that, because it's probably not the applicant. Have we approved them like this because they provided these extra width streets? Does anybody know, or, I mean, do you know?
I've actually got a couple examples with me, just
Oh.
in case of some other projects that were approved that you can take a look at. That one's called McKinley Oaks, and as you can see at about the midpoint in the project, there's a little turnaround area. That one got a specific approval for the cul-de-sac length.
You did.
This one you can probably see a little bit better. It's called Marshall Landing, and same thing, at about that 800-foot point in the middle of the project, you see an area for turnaround, and that was another project that received specific approval on that cul-de-sac length.
Okay, so, yeah. And I do want to disclose that I am related to the applicant, someone that's Scott, actually, and I swear, I affirm that I have not, I didn't even know he was the attorney till I saw him in the audience. So, but I want Bob, I just don't, it's unfortunate that we're here again, just because this is the whole premise of why we've denied this in the past. And now we're saying it's okay. And I want you as a public safety director to assure that this is not going to affect public safety or, your response time.
And again, I mean, I couldn't stand here before you and say never, obviously, but I can tell you that the biggest difference between why we're here today saying we have no objection and why public safety was here previously and said they did object, to me, the biggest difference is we went out and looked at it. We took our trucks out, we drove it, we found cars parked on the sides of the streets, we worked the turnarounds. I don't believe that was ever done by public safety previously.
Do you know if fire did that?
We did it with our trucks, and their trucks are just slightly larger, and we've got photographs of the trucks and the spacing and but Leslie, the fire department, and Leslie Aiden, representing the fire department, has also removed their objection.
Okay, thanks for now.
All right, I'm next on the board. Bob, you might as well stay there. You know my question.
Right.
I appreciate, and trust me, I wish this wasn't before us again, because I think it shouldn't be, considering, this goes back several years. But that being said, I hear about how the cul-de-sac is wide enough and everything, the lanes are wide enough for you to get your vehicles down, but you know what my question is. My question is, what if, say for instance, there was an emergency on the road, perhaps a house is on fire? Then you have people on the other side of that are stranded. They can't get through. They can't go anywhere. I think it's unfortunate that, number one, it was allowed to be built with this long of a road with the cul-de-sac. I mean, 1,000 feet's too much. How are you going to handle that? How do people how are they able to leave their homes in case of an emergency?
And that's a valid question, but it's not specific to this development. I mean, that could happen anywhere. The cul-de-sac I live on is less than 800 feet, and if it happened at the right point, the last 6 or 7 houses on that street are going to be in the
Valid
same
to me.
situation. It's absolutely valid. And I appreciate it, because in public safety, we work in a worst-case scenario, end-of-the-world kind of realm. That's what we do. Unfortunately, I'm not sure that our codes and our ordinances live in the same world. So I'd have to defer to Mr. Clegg and our planning officials to see if there's that leeway in our ordinances to object to a vacation based on a what-if of that type.
Well, let me ask my next question. You know, this just came before us a few months ago, maybe 6 months ago, maybe? You know, where we were talking about the gate, and the applicant had come forward as far as trying to figure out a different way to be able to operate the gate. And this board elected, well, 2 different commissioners, elected to have public safety look into this to try and come up with a solution to go ahead and get this gate operational, because I know that another development had put flower pots in front of it and so forth. And we had those removed because they weren't legal to be there. And I remember all that. And then it came back, and I know I had made several phone calls on this issue trying to find out what was going on with public safety in reference to that. And I had a conversation, I think it took 3 or 4 months for that to get settled in your department. And then I was told that you had had meetings with the fire department, the sheriff's department, and so forth, and you were going to leave the same sort of operations of gates as it has been in the past. So I thought, okay, well, at least we've got that settled. Now we're moving forward. Now all of a sudden I hear, and I don't know where it came from and how you ended up doing all this, but now I hear that, oh no, we're going to vacate, we want to vacate the street and close the gate altogether. So I'm a little confused why this board has been put in this position, you know, in the last year, and it's gone back and forth, and now all of a sudden we don't need the gate. I'm confused on all this, and I have to agree. I know someone up here said something about didn't like the smell of it. I'm concerned, and trust me, I know the developer. You guys, you know, the developer builds beautiful projects. I know University Place. I've been in there many times, and I understand where both sides are coming from, but at the same time, I'm kind of like, what's going on here? Why are we now in this position when we just were over here on the other side a few months ago? And it wouldn't have been built had there not been required, had there not been a reason. We do need to be able to connect our neighborhoods. We do need to have an access in case of an emergency only. You know, so I'm confused why we're here today, again, and I was confused the last time it came, why we were having to look at this then. So I'm a little bit, I don't want to say put out, but maybe that's the word, that this is even taking place today. But that's.
No, and I can understand. I mean, there's a lot of pieces to this. It's confusing, period. The biggest thing is the 2 issues you're talking about are separate and distinct, but tied. The issue that came before the board in August with the gate was not necessarily, when public safety got involved, was not a vacation request. It was a request to use a Knox box locking system on the gate. Again, public safety is on record as saying we don't care if there's a gate or not there. It doesn't matter to us. From the public safety perspective, however, if there is a gate there, it needs to comply with county ordinances. That's what came up in August. In August, the developer came forward and said, we don't want to use a remote control access system. We want to use a Knox box. And so the board tasked public safety to look at both the existing ordinance and the feasibility of using a Knox box. It did take about 3.5 or 4 months to do that, because we did have to meet with all the fire departments in the county, the fire marshals, the sheriff's office, and pretty much anybody who used those emergency gates to see if they thought the Knox box system was a viable option. It was unanimous across the county. Every public safety agency in the county said, no, Knox boxes were not a viable option. It was a step backwards and actually would slow response. So the Public Safety Department drafted a staff memo to the board that said, here's our findings, here's what we've gotten from the other public safety agencies in the county. And then I personally spoke with the developer and said, listen, here's what the findings are, here's our position, here's why it won't work, and the developer was in agreement with that a Knox box system couldn't work on the gate. So that was separate from the vacation request itself. So I hope that kind of clarifies some
Well,
of your
you
questions.
can't get rid of the gate without the vacation. That's why we're hearing this one first. So it goes hand in hand. Commissioner Burnett?
Yeah, I don't agree with that. I think we can get rid of the gate without the
can.
vacation. I have heard that this is private right-of-way. We have plenty, and even in Lakewood Ranch, I guarantee in Lakewood Ranch, we have rights-of-way that were not built through. We have cul-de-sacs longer than 800 feet. I have been here in this community for 30 years. One of the biggest issues has always been inter-neighborhood ties. It's still in our code. It's the number one thing that neighborhoods hate. They hate the idea of connecting to their adjacent neighborhoods. Everybody's going to speed through their neighborhoods. They're going to bring bad elements into their neighborhood. I guarantee that this has been an issue for boards long before I was on this board, because I used to be out in the audience or up at that podium, and that has been a huge issue. The idea, it's good planning. It's good planning to have inter-neighborhood ties, but it isn't necessarily what the neighborhoods want. So it becomes a huge issue. I'm very glad that we had an opportunity to look at some examples. The one that you have up there at Marshall's Landing is a great example, because that is obviously an area surrounded by the Braden River where you would have concerns, but they were able to put this little, we call them eyebrows, into the road to create an area to have a turnaround for an emergency vehicle. I think, when it comes to regulating public safety, and Carol, all of us, that's our number one priority. I know you're a nurse, I'm a planner. Our job up here is to protect the public to the greatest extent we can. But I can't stipulate everything that will make everyone happy. I used to say back when I was on the other side, and the planners would say to me, we need a stipulation because this is a good idea. I said, solving poverty is a good idea. You're going to stipulate my development that we have to solve poverty? I mean, we have to have common sense when we're looking at how we're dealing with land use. I think that there are mitigating circumstances here. The situation that they put in these turnarounds, the situation that we have adequate access, situation that it's right next door to a fire station. But if you look at Sneed Island, all of Sneed Island has one access.
True.
This happens throughout the county. And I know that it sounds scary to people, but I think we need to look at this realistically. And again, I've got an open mind, but I still think that we could change the stipulation to allow them to not have this connection today and leave it open in the future for the HOA if they choose in the future to have that connection. I don't see anything legally that prohibits us from doing that because we have that in other areas of the county. But I see the county attorney is going to maybe tell me something different.
I'll politely wait my turn unless you want me to respond to that now.
Yes, please do.
Commissioner Benak, the difficulty is that this is a platted access point. The reason this is in front of you right now this way is because there is a recorded plat, and I think it's 86 homeowners or something in that range, bought their lots in reliance on that. By statute, you can't, well, that is true under Florida law. That's how the judges view it. When you buy a platted lot, you buy in reliance on the plat. And so by statute, we are constrained in how we can change that. It's not like just changing a stipulation in a site plan. There are only limited ways under Florida law that you can make a change to a recorded plat once others have bought into that plat. The only way we can remove this access point from this subdivision under Florida law is through that statutorily authorized petition to vacate. It doesn't matter whether the right-of-way under it is public or private. You are correct, there is unopened right-of-way all over the state of Florida in every jurisdiction. That is true, but that's a little different from an access point on a plat where homeowners have purchased based on that plat. So we're constrained by statute in how we can make those changes. That's why we feel you really need to decide that first before you make that decision on the site plan as well. Does that make sense?
Yes, but,
That's why it's come to you this way, because we
Yes.
can't just change a plat. We can't just say, oh, well, we'll change the stipulation. Once a plat's been recorded, you've locked in that development for the people who've bought it. It only takes one homeowner to say, I object to that, and I bought in reliance on this, and you didn't change it through the proper statutory procedure, which in this case is a petition to vacate the right-of-way. Only one. It doesn't have to be a majority, just one.
No.
Can go into court and say, we have not followed the law the way we were supposed to in removing that access without making that change by statute through a vacation of the right-of-way.
so just to clarify, we don't have anywhere in the county where we have an existing road that is blocked off, is what you're saying?
No, I'm not
We do
saying
not have
that.
anywhere in the county where we have an
I'm not saying
existing.
that. I used to live in Kingsfield where there was an inter-neighborhood tie with a guardrail across from it. But the problem is, I mean, they still had to maintain that, we called them stub outs in those days. Back in the day during the boom, we used to call them stub outs. They were all over the place. You couldn't remove one once the plat was recorded without going through a petition to vacate, because the roads had been either dedicated publicly or privately. I personally have issues with private dedications of roads by plat, which is why I've questioned whether this is really a private right-of-way. But that's the way we're treating it. It doesn't matter, though. The distinction is immaterial, because by statute, once you draw that on a plat and record it and sell off land in lots to homeowners, you can't change it without going through the statutory process that's required to change an existing plat. It constrains what you can do with that land.
Well, let me clarify.
That was the developer's decision to proceed with recording that plat while they still wanted to make this change. And that put them in this position where we have to go through this process to do it.
Okay, let me change my question then. Can we allow them to dig up pavement and put grass over it in that location and still keep the platted right-of-way? Could we do that?
Well, that's an unusual question. I mean, that's basically saying the plat shows one thing and will allow them to do something else. I think, just off the top of my head, I would have to advise against that. Because we are supposed to, I could see a judge having a real problem with that, because the plat was recorded and it showed an access point there.
Okay, but we could. It wouldn't be a problem. Okay, thank you.
Commissioner Johnson.
Public safety question. When you're figuring out the response time, coming back down to the end of that cul-de-sac, do you factor in the fact that you've got a fire department right there at the entrance to this place? So, the response time's got to be pretty quick compared to somebody who's living a mile or 2 miles away, from a firehouse. Is that part of your analysis when you're looking at this?
It is. How the proximity of the stations that cover this particular area is counted into the response times predictions and things like that. And then it's statistics from there, the calls that we may have already be responding to in here, we've been tracking those as well. So it's all of that's factored in. The station itself and where it's located, and then how quickly we've gotten to any calls we may have responded since the houses have come online.
Okay, thank you.
All right, I don't have anyone else on the board, so we'll go ahead at this time and open public comment. I have one card, Rick Romanoff. If you would please state your name and
My name is Rick Romanoff.
minutes.
I have been sworn,
Thank you.
and I currently serve as chairman of the University Place Community Development District. This subject, as you have discussed, has been on here frequently. The district strongly encourages you to approve this vacation. Historically, when University Place was developed, we were under the strong impression that this was to be a emergency access only. Unfortunately, through the development of Riva Trace, that has been used for many other traffic other than emergency access. So we would like to maintain that. If it were vacated, we would like to see it landscaped, and hope that you will do that. Thank you.
Thank you.
Is there anyone else from the public that would like to come forward on this issue? If so, just please come up, state your name, and you'll have 3 minutes.
Linda, she didn't even live there.
Commissioners, my name is Terence Williams. I have been sworn in. I'm a resident of University Place community, and my question is really that we are a CDD community, and we have a bond which we are paying off. Riva Trace, the private community. If we are forced to join them, will Riva Trace contribute to our debt? That's my question. Because we have a $3 million debt, and we'd be quite happy for them to join us if they will pay. Thank you.
I'll respond to that after public comment. Yes, sir, come on down, please.
Good morning. My name is Jack Otto. I live in Riva Trace. I'm also president of the association. We personally went around to the neighborhood and requested people to sign their petition to remove the gates, put in the landscaping, block it off completely. That came from both sides, from University Place as well as from Riva Trace. If anybody else would take a drive out there, they would see the reason. It's impractical to have it. All it does, and the gentleman mentioned earlier, other kind of traffic, yes, we get other kind of traffic going over the fence and going to the river, walking through the neighborhoods. We want it stopped. We don't want it opened. We want it closed off permanently.
Okay.
And we're doing our best to make that clear to you folks. Thank you.
Thank you. It's clear. Yes, ma'am.
Linda Neely, private property rights. At the end of the day, we started this meeting with somehow portions of our county believing this was public property. Private property rights, if we would honor those, we wouldn't be here. Seems like the two groups sound like they had come to an agreement, and because it was a platted area, which I understand platting, even though, like at the school board, they kept saying a lot was too small to build on, because once it was platted, the lot is a buildable lot under your code. So the confusion comes from previous boards, statements by employees that we, the public, take as fact, which we should learn that we have to read the rule book, which is the legislative intent and your policy and procedure codes and your land use codes. And only then would we really know the truth of the matter, perhaps. But private property rights, they want to protect their private property. Let them.
Say if she was sworn.
Good morning. My name is Jack Cardin. I have been sworn. Ladies and gentlemen who serve as the County Commissioners of Manatee County, thank you for this opportunity to speak with you today regarding the proposal from Mandarin Development to delete the emergency access onto Meeting Street for our subdivision. First, I would like to bring to your attention the fact that this emergency access serves not only the 86 homes of Riva Trace subdivision, but 23 homes in University Place as well. All of the properties in University Place, whose address is on Meeting Street, will be affected by permanently closing this emergency access. So closing this access would affect 109 homes that would then only have a single means of entry and exit should an emergency arise. Emergencies in our neighborhood do not happen every day. But it is very easy for me to imagine a scenario where the emergency access would be crucial to our community. For example, a single house fire in the right location would close Rio Bella Place, the street that I live on, to all traffic. It would mean that any other emergency that might occur within the time frame of the fire would be subject to using helicopters or other extraordinary means of providing critical medical care to any persons in need. As I examine the role of you, the county commissioners for Manatee County, I recently visited the mymanatee.org website, and I read the page entitled The Responsibilities of County Commissioners. What do county commissioners do? In case you may not have visited this webpage recently, it mentions the Florida Statute Chapter 125.01, and it indicates that this board legislates policy to protect the health, welfare, safety, and quality of Manatee County residents. I can tell that this board is focused on, among other things, the safety of the residents of Manatee County. As you may recall, this hearing was originally scheduled for August 4th and was then postponed to September 1st due to pending litigation involving Mandarin Development. Then on August 31st, the meeting that was scheduled for September 1st was canceled in advance of Tropical Storm Hermione. I read with interest the statement of the county administrator, Ed Hunziger, who said, out of an abundance of caution, we're sending employees home and asking them to take necessary precautions for their families. I would urge you, the county commissioners of Manatee County, to exercise that same level of caution in dealing with this emergency access gate request that affects some 109 homes in the county. Thank you for your consideration.
Thank you, sir. Yes, ma'am.
My name is Beth Knoppenberger, and I live in Riva Trace on San Miguel Cove, and I have been sworn. Myself, as well as maybe 4 or 5 other individuals, were responsible for the petition that we took through the neighborhood. And we approached residents, and if anybody did, in fact, tell us that they were in favor of keeping the gate, there was no coercion. We just said thank you and moved on to the next house. In doing that, as well as in the letters that were sent from the residents in favor of the proposal to remove the gate, we have obtained 53 signatures of the 86 in the neighborhood that do support removal of the gate. And that ranges from people, from families with children, elderly individuals, working individuals. So it's not just one type of individual. We aren't in a flood zone. Some of these things have all been said already. We are fewer than 100 homes. And should a fire occur in the wrong place along Riobella, that gate wouldn't help anybody. So I just want to let you know that we do have support. That means 63% of the Riva Trace residents do support the proposal to remove the gate, replace it with a fence and landscaping. Thank you.
Good morning, Commissioners. Bob Bolus, Riva Trace, San Miguel Cove. A little of my background, from Scranton, Pennsylvania. I was a first responder. I've been in the towing recovery service for over 54 years. I'm an instructor for the Northeast region on emergency procedures and responding to fires or hazardous situations. The reason I purchased in San Miguel on the Cove was because of the emergency exit. Looking at the river on one side, the creek that runs coming down the main road. In any event, that passage is blocked. The only access to my area and further out towards 75 is through the emergency gate. If you take nature, a groundhog has an entrance and always has an escape route. This was put in by the developer. The people here before that were speaking from the development, I don't even believe they have standing anymore because of the way this has been changed and moved on since it was originally built by Medallion Homes. I purchased my property based on what was presented to us, and that was the emergency exit. It was important for me, especially on San Miguel Cove, where we're at the end of it. We're isolated. And as a first responder that has responded to thousands of emergency situations, been given a certificate by the Florida Highway Patrol for my heroic actions in stopping a wrong-way driver on the interstate, and other stuff by the American Towing Association, I believe I'm very qualified to stand here today and challenge. As a firefighter in a volunteer fire department, I drive the fire engine. Do I need to do it? No, but it's right close to one of my businesses in Pennsylvania. We always look for a second route, knowing that if the route that's the closest is blocked, like here, if the fire department's right outside the gate. But if that access road is blocked, you do not get to San Miguel Cove or anywhere else down toward 75, other than through the access road. It's a gate. It's not used for personal business. It's an emergency situation. And I implored this commission to consider the safety of all individuals. I was never asked to sign a petition. I would not have signed a petition jeopardizing the public safety of myself and the others in this development. In Pennsylvania, I'm a developer. We always make sure we have access, ingress, and egress to protect anybody in any development I'm involved in. And in this, it's a critical need considering the situation. You're only looking at one way in and one way out that does have the potential to be blocked. Thank you.
Thank you. Yes, ma'am.
Hi, I'm Debbie Cox. I have not been sworn in, so could somebody?
This is legislative. You didn't need to be.
Okay. Sorry about that.
That's fine.
Anyway, I wasn't planning on speaking. I appreciate everybody's listening. I am the homeowner of Lot 38. My backyard is at the gate. So just from my standpoint and the safety, and I agree with everyone else with the safety, I do not want the gate there. It's been a problem for me. It blows down, it falls over. Right now, we have chained it back up. UPS hits it, the trash people hit it. It's constantly open. And that's what a lot of, I think, other homeowners that don't live where I live realize that because I'm the one picking it up. So I think the next time that it happens, I'm just going to leave it down and then they'll really see about the access. Because the access that comes in and out is when I'm not there to pick it up and replace it. Now, if you keep a gate, I don't know who's going to repair the gate or maintain the gate. I don't know if it's University Park or I don't know if it's Riva Trace. I don't know if they understand the impact of that. I'm sure it's not the county that's going to pay for when it falls over or doesn't open or stays open, doesn't shut. Just my view. I thank you for your time again. I would like the fence. I think it's a great option, but my safety is important when it's open. Thank you.
Is there anyone else from the public that would like to come forward on this issue? All right, we will close public comment. Commissioner Whitmore.
Well, it's nice to hear from the public. I didn't realize that there was that much support to vacate this. So it's nice to hear from both HOAs, so I'm glad we had that. Somebody mentioned about helicopters, you would have to come beside the ambulances. No, well, it doesn't happen because the ambulance has to come and call them first.
Yeah.
So that's still what would happen. Just, I want to rest, whoever that citizen was, I want to rest them assured that our ambulance will still be there, and then they call, depending on the criteria of the injury or whatever, then they'll call the helicopters if needed. And then where you live, the helicopter probably couldn't land there, and they'd have to transport it somewhere anyway. Our current ordinance doesn't require a second means of access unless it's more than 100 or more homes. So, and this is 83. So I get that. This gate has been a pain for everybody. So we are going to have to just make that decision on what we think should, what should happen. So I'm glad to hear from the homeowners because I thought you're all here to yell at us. So, because some may get more emails than others, but, I got a few, and usually it's the ones that don't support it. And I got maybe 5 or 6. But so it was good that you did do a poll, at least in Riva Trace. Yeah, it's your guys' area. So us at-large commissioners, we don't get them all. So it was good to hear from the public. But, my whole deal is public safety. And public safety has been before us every time and said that it wasn't going to work. And then they actually went out and eyeballed the development. And maybe we should, like, ask that in the future when we have contentious things like this, have our staff go out and look. Because this probably would have stopped 2 or 3 of the meetings. So I'm glad Bob, who is new with us, and I'm glad he actually went out with the trucks to see if it'll work, because that's all I care about. If you're having an issue, I want somebody to get there as soon as possible. If it takes 30 seconds, 45 seconds longer, once you get, I mean, that isn't usually gonna help anything, 30 or 45 seconds, a minute. But he is rest assured that he can respond. So I'm gonna be interested to see what the rest of the commissioners think about it, but I am very appreciative that the citizens actually did their homework on both developments and came to us. So we kind of know how you feel about it, not just us sitting up here doing something, so that's all.
Commissioner Benek?
I just have a question, because I live on a cul-de-sac, and this idea that a fire truck can come and block my road and I will have no access because I live on a cul-de-sac, that's kind of news to me, that a fire truck, and I know we don't have anyone from the fire department because our fire departments are not part of the county, they're independent districts. But I wonder if Mr. Smith, because I'm sure he works very, very closely with fire districts, I mean, I'm not familiar with fire trucks generally blocking access on neighborhood roads. If that is a standard, I'm not familiar with it. But luckily, we've never had a major fire on my cul-de-sac, so perhaps I've just not experienced that.
Mine either.
We have on mine.
Cul-de-sac.
Thank you, ma'am. Bob Smith, Director of Public Safety. And I put 14 years in the fire service before I came to Manatee County, so I can speak to this a little bit. There is the possibility that depending on where the truck parks or what type of truck it is, that it could block the street or block a vehicle in, and that is not uncommon. However, firefighters are also part of the community, and they do everything they can in community engagement to work with the community, so they try to go out of their way. But it's not uncommon for that to happen. They can block streets. Hoses going across streets, they make devices you can put over hoses so cars can drive over them to not block traffic. So they try not to, but it's not uncommon for a street to be blocked or a car to be blocked in by a fire truck.
Okay. And then I had another question about the road has been constructed, and Thomas, maybe you know about this. The road has been constructed to a local road standard. So to rip up the road, do they just take the pavement out and leave the subsurface? Isn't it possible to put grass over the subsurface and leave the subsurface and not rip that out and have, and I don't know, maybe it's a question for Joel. I don't know if the grass can grow if they were to do that, if they were to sod over the subsurface of the road without removing the actual road bed, if you will.
Commissioner Benek, it is possible to remove the asphalt friction coarse pavement, which is typically anywhere from 1.5 inches to 2 inches in thickness, and to leave the base and the sub-base material in place and basically to sod over the top. That is actually one of the design preferences as far as providing an emergency stabilized access and any other type of development throughout the county, whether it be for cul-de-sac or to means of access. That is a design that is utilized elsewhere in the county to have a sodded, stabilized access point.
Okay. So it would be possible to do that and to put up a fence that, granted, in the event of an emergency, would have to be removed and not have the gate, recognizing, and I know, I'm glad the gentleman's shaking his head, he's absolutely clear this is not what he wants, and I understand that, but I just wanted to make sure that it could be done. And if there were a fence put up, it would have to be maintained by the HOA of Riva Trace, right? I mean, they would have to maintain it because it's their right-of-way. Is that the way, anything in that right-of-way would have to be, even today, even it being private right-of-way, has to be maintained by Riva Trace HOA. Is that correct?
Commissioner, that is correct, yes.
Okay. All right, thank you.
All right, I'm next on the board. First of all, I wanted to get back to what Commissioner Benek said about fire trucks and blocking roads and so forth. I can tell you on my cul-de-sac that I live on, there was a fire at a home about 3 years ago, maybe 4, and it literally blocked the entire road off. It was hit by lightning, and it was pretty massive. I mean, the house was a total loss. So it does happen, and it could happen. I am surprised at the 63% in favor, because I can tell you the emails that I've seen, and I got a whole bunch more than 5. And from now on, Commissioner, since you are at large, I'll make sure you get all of mine too.
Well, we would kind of appreciate it.
But yeah, I'll make sure they're all sent to you. But that being said, you know, I hear 63% in Riva Trace are in favor of the gate being removed. I'm real surprised at that, and I'm glad that it's on record, and it's being recorded. I'm sorry, you can't, I'm sorry. Because if anything should come up, you know, I want you to remember that, you know, 63% of you didn't want that gate. So, with that being said, that's all I have. Mr. Clegg, I'll be with you in just a minute. Commissioner Trace.
I'm surprised by the 63% myself. I have a kind of a problem with changing midstream, so to speak. It just seems to me that, you know, the whole thing was sold with the gate in place that the developer was supposed to provide, and somewhere down the road, they keep changing their things. If 63% of the people, because I'm a big private property, if 63% of y'all think that y'all don't want the gate, okay, but I'm with Chairman Benak. Not having 2 accesses is not the best position in your place, and we're giving y'all are telling us y'all don't care. And like I said, it could come back to haunt y'all one day. But if that's what most of y'all want, I'll vote for it. And I was in here positioned today to say no because, like I said, I grew up with only 1 access. When you're 8 and 9 years old and you can't go to school, it's a good thing. But when you're, you know, 40 or 50 and can't get to work, it's another thing. And when the creek came up, we couldn't leave, and we were on our own. And the county wasn't going to come help us or anything. And basically, if we'd have had an emergency, we'd have had to swam the creek and run down to the neighbor, and the neighbor was not close. So,
That sounds good, though.
but if that's what 63% of you want, I'm not, you know, I personally think y'all live there, I don't. So, but I'm surprised about that, and I really am hesitant about letting this go, because I personally think it's a bad move.
I do too. Commissioner Whitmore.
And, you know, I mean, actually, I came not supporting it at all, but then the 63% after the citizens spoke, I mean, and also the development next door to it. Betsy, you mentioned a fence. I'm familiar in my city, when I was out there, with the movable fence. Is that what you're talking about?
Well, I think,
Can
can I dialogue?
contact? Because
Yeah, I think that we were talking about a breakaway fence.
Right.
At some point, we were talking about a breakaway fence, and that was when we went to look at our standard, whether we could change it, and the response came back, no, our standard for an emergency access is not a breakaway fence. It is the whatever controlled gate, not a Knox box, not a breakaway fence. So we got away from that.
Okay.
I am familiar of other places, other times when breakable fences were put in, the idea that somebody could get through a breakaway fence. I don't know what the fence that they want to propose. What is existing fence? Do you know? Just a wrought iron fence is my understanding is the existing fence. And that's what they would want to continue across is a wrought iron fence, which is not a breakaway fence. So it would be different than a breakaway fence.
And again, I agree with Priscilla on this one. 63% kind of, it's a democratic way, and then the development next to it. So I'm tending to support it right now, unless somebody tells me something different. I'll change my mind. I've already changed it twice.
Commissioner DeSabatino.
Well, our county standard is, if you do the survey through Public Works, it's 67% have to agree. So we're a little short, and Mr. Gibellina knows when you don't get 67, it doesn't
sewer.
have.
That's for sewer,
Oh, that's-
That
Robin.
was for speed bumps
Yeah.
and
That's
changing
Stone.
It is
anything
for
else.
speed
That's
bumps.
totally
That was for
different.
speed bumps.
It is.
So, jury's still out on this one.
I went there. I'm next on the board, and I just want to comment on something that was said by a citizen. who wanted to know if Riva Trace was going to contribute to your debt because you're a CDD. Well, interestingly enough, I do want to respond to that because I live in a CDD as well. No, they would not. And here's the reason. That gate would only be open and used in case of an emergency. It's not there for anything, it has not been there in the past, for anything other than emergencies. It is not supposed to be used. I heard FedEx, I think, mentioned. I don't think FedEx would be able to use it and should not be using it. It's strictly in case of an emergency. And I'm sure that there is no one in this room, if there was an emergency in Riva Trace, I'm sure that no one would want to hinder a human being in trying to make sure. We would want to help because that's our nature. So I just wanted to mention that, but no, they would not contribute to your debt. Commissioner Johnson.
Just, again, one question, so we don't have to come back and revisit this. I assume we have some idea who's going to pay to rip up the road, maintain it, take out, put the fence in there. I think I know who that is, but I just want to make sure that that is on record, that it's not going to be the county's obligation somewhere down the road to have to cut a check to do all this type of work.
Madam Chair, Commissioner Johnson, because the developer has taken the position that this is private right-of-way, there's really not a basis to make us do it. That's not our responsibility. It's
You just say
not
that.
public right-of-way.
So you just
So,
said it.
yes,
So
ma'am.
you're saying that the developer would have to do that,
Yes,
not the county?
or the homeowners association, some private owner within that development.
Okay.
Well, I'm not seeing anyone else on the board, so what is the pleasure of the board?
Madam Chair, could I just,
Oh, I'm sorry. Do you want to respond?
It's 11.
I'm ready to go on this. I mean, we're.
Commissioners, this is a unique position for me to be in, to have a situation where the developer, the residents in the community, and the adjoining residents all agree.
Weird.
So that doesn't happen that often. But to answer your question, yes, the developer is going to be the one to remove the asphalt and to put in the landscaping and the permanent fence there.
All right, thank you. Mr. Clegg?
I did want to just make a couple of remarks just to kind of wrap up on the legal side of this. As I stated at the beginning of this discussion, it is a legislative matter. That means that the standard of review for the board's decision is what we call the fairly debatable standard. It's a little unusual for you because you're talking about issues that relate to land use and development, and you're all used to handling that, looking at code provisions, listening to testimony of people like the public safety director. But at the end of the day, as long as you have a solid, plausible basis for going one way or another, and we are decidedly neutral in the county attorney's office on that, as long as you follow the right process, you can go either way and we can defend it. I am comfortable you have followed the right process to get to this point, and I want to state that for the record in case anybody questions it later. And finally, once again, Commissioner Benak, because we have to change something that's on a plat in which people are residing, we have to do this first. If it is approved, then you can go to a land use hearing next and talk about what you're going to put there instead of what the plat reflects.
Oh, got you.
That's why it's sequential. That's why we have to do one first and then the other.
Well, if I could ask a question?
Yes, go.
Well, I know how I want to vote, and I'm going to tell you how I want to vote. And you're going to tell me whether or not that is something that you would advise against. I want to vote against the vacation, but I want to vote for a stipulation that allows them to remove the asphalt and to be able to landscape it over. Is that something you advise me against? Because there
Yes.
will no longer be a road. There's a possibility of a road in the future, but
It
there
is,
will
and
no
I
longer
know
be a
from
road.
your experience dealing with development, you know we have built stub-outs. Built stub-outs in subdivisions all over the county where they're still paved with a guardrail in front of them. And they have to stay there, because in order to remove them, we have to update the plat, because there's been a recorded plat put in place. So it's not as simple as just changing a stipulation. So if you want to get to the end point of landscaping it over, you do need to approve the petition to vacate to get to that point, in my opinion.
And my reasoning for doing that is because the more accesses, the better. It's just a fact. It's just, the more accesses, the better. And I get it that people want privacy and they don't want to have that connection. I get that. We see that. But from a public safety and a planning perspective, that's where I'm struggling with this. But I get it, and I'm struggling with it knowing that the Land Development Code might not have required this. There's been a lot of strange things that happened with this application along the way. I get that because it started out at one thing and changed and changed and changed. And I'm not at all surprised that the neighbors and both sides want to get rid of this. And so that's all I'm going to say.
It's been a mess.
I'm going to stop talking now.
I've been on the board.
I'm going to listen to the applicant.
Commissioner Whitmore.
I'll make a motion to adopt resolution R16-116.
Second.
Is there anything that the applicant would like to add before we go with the motion?
I'll answer any questions from the board, but I don't think there's anything else to add.
Motion now.
Commissioner Benak, I have you on the board.
Oh,
Is
I'm
there-
sorry. I spoke.
All right, well, we have a motion by Commissioner Whitmore, a second by Commissioner Johnson. All in favor, say aye.
Aye.
Aye. All opposed, nay.
Nay.
We need a hand count.
We need a hand count. All in favor, say aye. Or, I'm sorry, raise your hand.
So it died.
Died.
All right, it dies. It's 3-3. We
That's
don't
correct.
have another vote, so it dies. The motion dies.
So does anybody else want to make an?
Madam Chairman?
Yes,
I
ma'am.
voted with the understanding that I could still go forward on the next application and make the change. I understand it's not recommended by our legal department, but I understand what the people want. They want to have a closed-off access with an underlying platted right-of-way. I'm only going to do this, if not, is there a prevailing side on a 3-3?
If it's a tie vote, it's a denial under our rules.
Is there a prevailing side to make if you're telling me that we cannot consider the next one, then I'm going to change my vote.
Yeah, you really cannot consider the next one if it dies.
All right,
The
well, I'm going to
petition
change my vote
vacate is
and
not
vote in
approved.
favor of the vacation then. Can I do that without just saying it here? Can I
I
do that?
think that's the discretion of the chair. If you
Yeah,
want to.
well, I mean, obviously, I'm going to allow it. You
Yeah.
know, We just,
Yeah.
so, all right, then we'll go back. How do we handle that if we've already voted on the motion? Do we just,
I said that I'm on a prevailing side, and when it's a 3-3, that's what I was going to do, make a,
Any.
Motion
you know,
for
if you
reconsideration.
want to strictly follow the process, anyone on the prevailing side can move to reconsider to give you the
Okay, so you're
opportunity to take the
reconsidering.
vote.
I make a motion to reconsider.
Second.
all right, we have a motion, thank you, that's what we have a motion to reconsider by Commissioner Benak, a second by Commissioner Whitmore. All in favor, say aye.
Aye.
All opposed, nay.
Nay.
5-1, that's interesting, okay. All right,
Do we have to go through this again?
yes, no, I cannot make the motion, so somebody help me here.
What, we're on 14 or?
Motion for what?
I move, where are we? What number are we on, guys?
14.
We don't have our little person
Resolution
helping us.
14.
Okay, I'll make a
can't
motion
do
to approve resolution R16-16 vacating a portion of improved right-of-way at San Miguel Cove, University Park, Florida, PID 19189155359.
We have a motion by Commissioner Whitmore, a second, do I hear a second? By Commissioner Johnson. All in favor, raise your hands. All opposed, raise your hands. It is a 4-2 vote, so it is approved.
Okay. Don't come back.
I don't want to hear it.
Yeah, we don't want to hear it.
I don't want to hear you're stuck.
We don't want to hear it.
Just remember,
Yeah, you
it's
get
your
stuck,
decision.
you're on your own. Call your own helicopter.
Amen.
Nicole, would you like to go ahead and read in item number 15, please?
I would, and I have a clarification question. Since their companion requests, do you need a full presentation by staff for basically the essentially of everything you've just heard?
Commissioners, do we?
No.
No.
Just need to open the hearing,
Yeah,
call for
correct.
public comment. People do need to be sworn if they're going to
And
speak.
this is a judicial hearing, by the way.
Item 15 is PDR 0414R3, or PR3, which is Mandarin Development, Inc., Riva Trace. This is a request to amend and restate ordinance PDR 0414PR pertaining to approximately 41 acres west of I-75, east of Honore, and south of the Braden River, approving an amended preliminary site plan with the sole change being to delete the emergency access onto Meeting Street, deleting stipulations A1 and A10, and renumbering the remaining stipulations, plus adding a new stipulation, A13, addressing a landscape buffer at the former emergency access point.
All right, this is a quasi-judicial hearing, so has there been any ex parte communication? Commissioner Benak?
No ex parte communication.
Okay. All right, no, nope, all right. Then we'll go ahead. I don't think we need a presentation. Commissioner Benak, I just took you off the board. Did you want to?
Yeah, I just wanted to ask a question of staff.
We do need to also give the applicant the opportunity to speak if
We
the
will.
applicant is so inclined.
I just want to ask a question of staff. The existing right-of-way in University, what's it called? University Place, excuse me. I can think of it as University Lakes. University Place. So that existing right-of-way remains. It serves as access to all of those homes, but it doesn't have a turnaround at the end. Did it have a temporary turnaround before Riva Trace was built? So at that dead end? I don't
think he would know. I think.
Is there a temporary turnaround ever considered back then? I assume University Place was built prior to Riva Trace.
It was.
No, so it's just a dead end right now. So how is it posted anywhere in there that there's no access? Maybe there needs to be posted in the neighboring subdivision that there was no out, what do you call that? Dead end street.
Dead end street.
Yeah, dead end.
Probably
normally
need
there's
to have a
sign.
posting on that or something saying
Private
dead end street.
community,
Well-
they can do what they want.
They can post whatever they want?
Mm-hmm.
Okay.
That's why you live in a private.
And let me ask another question. I just want to make sure. So, let's say in the future, because of the vacation, the two adjacent homes get the property of the vacation that we just approved. The two adjacent homes get the property, right? Isn't that how it works in a vacation?
No, that's not correct. The plat that was before you, the plat of vacation was, I don't know if property management has an exhibit they can place up on the dot cam. It's just the 40 by 15-foot width of strip that acts like a landscape buffer.
Common area on
It lies within a common tract around the edge, so when you vacate, instead of going to an adjacent property owner, it goes to the tract.
Oh, so it is still a common tract. And
my
if
understanding.
there was a change of heart by the,
No.
Sorry, Madam Chair, I'm sorry. We do need to have people state their names and state that they've been sworn when they're answering these questions for Commissioner Benak.
It's
If we could
actually, she's
Stay
right.
on quasi-judicial protocol, please.
Well, I believe staff has been sworn, so we don't have that issue at this point, but we'll get to that in just a minute.
They need to say their name.
For the record, the testimony on the tract and how the property reverts to the tract as opposed to the adjacent property owners offered by Clark Davis,
Thank you.
Transportation Planning Division Manager, and I have been sworn. Thank you.
You have to.
and so, all right, so it becomes a tract, and now what we're proposing is a change to the stipulations to change so that tract will now be landscaped and the road torn up and there'll be a fence and it will be maintained as part of the HOA. I just want to make sure, because we're
no, you're right.
acting on this, I want to make
I'm
sure.
sure the applicant will
Nicole Knapp,
comment on
and for the
that.
record, I have been sworn. Would you like me to read stipulation 813 into the record
Yes.
to clarify?
Yes, ma'am.
I'm sorry for the interruption. County Attorney Mickey Palmer, we need to be clear. This government does not offer up title opinions from this dais. It may very well be that the lands revert to a common tract. We do not offer title opinions in terms of what the ultimate result of the vacation will be. That's going to be up to the developer, and if there are any disputes with the homeowners in terms of vesting of title, that is their issue to address. But this government does not offer title opinions. We are not in that business. So I just want to make that clear for the record.
And Madam Chair, to add to that, Commissioner Benak, it's not really something that you have to take into consideration in terms of who owns it and deciding what you think the appropriate resolution of the site plan issue is. You're going to now acting in your police power over the land use decisions So the best thing to do is look at the plan, look at what the applicant is asking for. This is the applicant's request, and decide whether or not you're comfortable that it meets the code and comp plan.
Okay. I had another question, but I'm
And,
going
you
to
know,
wait.
I'm going to go ahead, but I do want to make one statement. As many times as this has come before us, I think that's probably why you're seeing so many questions being asked, because we don't want to see it again. So please don't. You'll get us, we can't have that, but. Would the applicant like to come up and give us a small presentation? I don't think we need a big one.
Commissioners, for the record, Scott Rudisill. I've been sworn. I'm here on behalf of the applicant. As far as a presentation, what you're going to see in that location will be a permanent fence matching the fence that is existing around the rest of the perimeter of the project, as well as a landscape buffer to match the landscape buffer around the remainder of the project. And that's really the extent of the request. This is going to eliminate the emergency gate, which can be unreliable in cases and can open and can be accessed at times in other communities by UPS and FedEx drivers who get that clicker. So we think it's better for security and aesthetics, and that's the reason we're here.
All right. I'm going to go ahead at this point and open to public comment again, and I need to make sure, is there anyone that wants to speak that has not been duly sworn? Because this is a quasi-judicial. Have you been sworn, sir?
Yes, I have.
Okay. The first card that I have is Jack Carden. He's gone? Okay. Okay, so I don't want to speak again. Okay, well, I was on item number 15. If there's anyone else from the public, please come forward. Just state your name and that you have been sworn, and you'll have 3 minutes.
Thank you, Commissioners. Bob Bolus. I have been sworn. One question I have is whether or not the developer has standing, since this has already been turned over. I don't believe the developer has any standing in doing anything regarding this emergency exit. He's out of the picture. He shouldn't have any say in any way, shape, or form regarding it. It's been turned over. He's no longer involved in the development. Second of all, I want to make this for the record to each and every one here. As a first responder, Commissioner, you saw me shaking my head. Let me explain very clearly. When you cut off an access, and it's an emergency access, as a first responder, it's my responsibility to get to you people, either as an EMT or as a fire department driver of a fire truck, to get to your home and save your life or your property. When you cut this access off, and it could be because the creek overflowed, it washed away, or there's a gas explosion on the main road coming in that denies access to a fire truck or an ambulance, and you're trapped on the other side of the little creek where that right-of-way would have been, and you die or suffer permanent injuries, I want each and every one of you to know, don't look at this commissioners and blame those that really were against it and went because you wanted to be the majority. I'm against it. I voiced my opinion, and I want each and every one of you to know that you may have
Madam
just
Chair, I
put
do have to
yourselves at
interrupt.
risk.
Sir,
Okay?
excuse me.
And as a resident
Okay.
there, you
I'm
put us
sorry,
at risk.
you
I'm
cannot.
sorry,
You
Commissioner.
need to talk to the commission.
Yeah.
not
Ma'am,
to the
I'm
room.
sorry, Commissioner, but I'm accustomed to addressing boards in Pennsylvania and
sorry.
stuff that I've
In
done.
this-
I'm sorry
this
for that.
room, you'll need
I
to address
apologize. My issue is that I think this was a gross error. It was only an emergency exit. It wasn't for traveling in and out. I think what's happened here today, these people have put themselves at risk. They put myself at risk and all of us that are in San Miguel in the Cove, that are on the other side of the creek if it overflows and we don't have access or ingress to get out of the development. I just wanted to state that for the record. Thank you.
Thank you.
Madam Chair, could I need to state so that everyone understands, when you're testifying, because we have to act like a court, please direct your testimony to the tribunal just as you would to a judge. It's very important for our record that you do it that way.
Thank you. Again, my name is Jack Otto. I'm president of the Riva Trace Association. And the access he's talking about, Mr. Bolus is talking about, if the University Park or University Place access was used to get to his house, in contrast to coming from the fire department directly, it would take him longer time.
No, I'm going to interrupt at this point. If you have any comments that you would like to make on item 15, that's fine, but let's not refer to other comments that's been
Thank
made,
you.
please.
We're in favor of removing the gates and putting up a permanent fence.
Thank you.
Thank you.
Anyone else from the public want to come forward?
My name is Rick Romanoff, Chairman of the University Place Community Development District, the owner of the street on the other side of this fence.
Again, let's keep it in reference to item number 15, not to other people that have spoken, please. And if that's where you are, great.
Just wanted to advise you that based on the vacation, we'd like to put our potted plants back. Thank you.
You mean the ones that we had to ask you to remove those? Okay.
Hope you kept them watered.
Yeah. Anyone else from the public like to come forward? Not seeing anyone else, we'll close public comment. Commissioner Benak.
I just want to make sure we heard the applicant say that they would be removing the pavement. I want to make sure it's the applicant and not the HOA that has the responsibility of doing these improvements, complying with this stipulation, and that you have proffered that freely without whatever we do, don't do up here. If you could clarify that.
Yes.
Commissioner, that the applicant is the one who will, well, I guess in this case, the applicant is actually the HOA, but the developer is the one who will perform the removal of the asphalt and the installation of the improvements.
So Mandarin is, I'm not sure what Mandarin?
Mandarin
Yeah.
Development.
Homes?
Mandarin
Homes
Development, Inc.
will be responsible for the cost incurred to make this a landscaped, fenced area.
Correct.
Is there a hedge there? Will you plant a hedge as well? I don't know if there's a hedge.
It's got to be nice.
It's gonna be, it's gonna,
Doesn't matter.
I assume a 15,
the existing 15,
15-foot green belt buffer, it will match. Okay, I just want to get
I want
clarification.
pansies.
Question?
Can I finish my
Yes,
question?
yes, I'm sorry, I was trying to.
Just wanted to make sure that we got clarification that it will be at the cost of the developer and not the HOA to install the continuous buffer that exists, and it will match.
That's
Because,
correct.
these kind of things,
It's
I
important.
will hear from people if it doesn't work out. We know that. So we're trying to finish this. I just want to get it as clear as possible.
So it doesn't come back again. Okay, thanks, Scott. Yes, ma'am, yes, sir.
Madam Chair, I do have another question for Scott. We've heard a couple of times or seen in emails assertions that the applicant in this proceeding lacks standing, and the gentleman that spoke a few minutes ago stated that. And going back to Mr. Palmer's advice, we don't provide title opinions about who owns what within a development. We have a process where we require an affidavit that states that somebody has the authority to submit an application. So, Scott, sorry to do this to you, but I do think it's appropriate, if you would please, to just briefly state why your client, the applicant in this proceeding, does have the authority and standing to bring this application for the board, so we have that on the record.
Again, Scott Rudisil, for the record, the applicant is the association, and that's who made the application. Any potential challenge to that would be a private matter between the homeowner and the association, and they would have the ability to do that.
Thank you.
I thought that was the case. I didn't think Riva Trace had been turned over.
Right.
Is that correct? Yeah, that's what I thought.
It has been turned.
It has been turned over?
Yeah.
It has? Okay, I didn't think it had. Did that happen recently? Okay.
After your August meeting.
Okay, I knew it hadn't been. Okay. All right, well, I don't see anyone else on the board. So is there any other comments that staff would like to make before we move forward?
Madam Chair, for the record,
Yes.
I would like to read stipulation 13.
Okay.
I'm sorry, Nicole Knapp, and I have been sworn. The applicant shall remove any asphalt and base material from the 600-square-foot portion of the vacated right-of-way known as San Miguel Cove. Shall remove the existing emergency gates separating the Riva Trace and Carriage Run at University Place subdivisions. shall install landscape and fencing consistent with the existing fencing and buffer, and shall provide a permanent drainage and utility easement over the area that was vacated. These changes, as shown on the revised preliminary site plan, shall be made within 90 days of the approval of this zoning ordinance.
All right. Thank you, Nicole. What is the pleasure of the board? What is the pleasure of the board?
I'll move approval of the stipulation. I mean, of the change to the, whatever, move approval of the recommended motion.
Thank you.
Yeah.
I'll second it.
All right. We have a motion to approve by Commissioner Benak, second by Commissioner Johnson. All in favor, say aye.
Aye.
All opposed, nay.
Nay.
It is approved 5-1. Thank you. We will take a 5-minute break to give everyone time to leave chambers. And I just want to announce at noon, we will recess for lunch and come back at 1:30. Please.
Yes, item 16 is ordinance number 1649. It's a temporary moratorium, medical marijuana. This is an ordinance regarding medical marijuana, imposing a temporary moratorium on the establishment and operation of medical marijuana dispensing organizations and medical marijuana treatment centers within unincorporated area of Manatee County for a period of 180 days.
All right, and this is a little bit of an unusual one. Because of some of the comments that I've heard, I just wanted to make sure I said in the beginning of this that this is not a moratorium to stop medical marijuana. It is state-approved. We cannot stop it. It is strictly giving us a little bit of time to put some rules together on how we need to handle this. And that's it. And also in waiting to hear from the state. So that being said, Commissioner Benak, you're on the board. Did you
Yeah,
wanna-
and I wanted clarification because I asked that question and there's people that says we're delaying the people's will. It's my understanding the state will not be ready to even issue anybody the ability to gain medical marijuana until October, so we're not in fact delaying
No.
anything. Is that true?
What's your name?
I don't know, we're probably
Yeah, come on.
jumping in before you do your.
We're jumping in, but go ahead.
Okay, yes, Fred Goodrich, I'm the case manager for Building and Development Services. To try to answer that question is Amendment 2, that's what gave us the medical marijuana. There are some provisions in Amendment 2. One is a 6-month window and one is a 9-month window. The 6-month window, the amendment said that the Florida Department of Health needs to prepare enabling regulations so that we know what we're going to be doing. The amendment itself specifies certain conditions, qualifications to be able to use medical marijuana. The 9-month rule is that there has to be the issuing of certificates for qualifying patients saying that, yes, they can use medical marijuana. So the Department of Health can take that long under Amendment 2. They don't necessarily have to take that long. So it could be that they'll be ready. I've had some conversations with folks at the Department of Health, their compassionate care unit. They seem to be moving ahead pretty quickly, so maybe something will come in the next few months.
So, Madam Chair, I think to summarize, it's what we call an amendment to the Constitution that's not self-implementing. It requires the state agencies to put together some regulations before anybody can come in and ask for a permit to begin offering medical marijuana. And those regulations, there's a time period in which the state has to adopt them. This moratorium, we took a pretty conservative recommendation of 6 months. So it's, in our view, not likely that it's going to extend beyond the time that the state is putting its regulations in place. But of course, we can come back to the board and talk about that if we need to as we go through the process. And your description of why we're doing it and what it does is exactly right. It is not a prohibition on medical marijuana. A lot of jurisdictions are doing this right now because it's a new use that frankly, our codes just don't know how to deal with it. So we need some time to make sure that we put the amendments into the code and possibly the comprehensive plan that handle it appropriately.
And I mean, you're absolutely right, because we don't have anything in our code on that. So it is something that we need to address and address quickly. Commissioner Whitmore?
And I like your terminology, Fred.
Yes.
Compassionate care. I support medical marijuana. I voted for it. And when I'm reading last night on the blogs before I went to bed, which I shouldn't have, because then I got mad, couldn't sleep. But, we are not trying to do that. I don't know what will be the outcome, but we do need to have processes, just like when you have a bar that's next to a church or a strip joint that's next to a daycare. I mean, it has to be zoned somewhere appropriately, and there has to be processes, just like we have other uses. And so, I hope that if nothing else comes out of today, that that we are going to follow the laws, and we are going to make sure that our community decides, we as policymakers, where we want to have those dispensaries and the process to get them when it's time. And that there are processes for physicians. I think it'll be by state law how to write the prescriptions. I know an extended family member that she's gone through breast cancer. She had chemo and radiation. Her local doctor here, there is a marijuana pill, Muranol, that you can order, and she ordered it for her. And so, there are uses for it, and physicians are writing for that here in Manatee County. So I'm looking forward to see what happens, and just to make sure there's a process that's controlled, and it's going to be used for the purposes of what we voted it for.
And I would just, as a follow-up to that, I would say, this moratorium gives us an opportunity to review all the laws. We've got the Florida statutes, we have Amendment 2, and whatever the Department of Health will be coming forward with. We want to get this right. We don't want to have to come back 2 or 3 times and have to continue and amend and amend and amend. We want all the regulations, all the rules in front of us, then we can put together an ordinance that we can bring before the Planning Commission and the board.
Thank you.
Yes, it doesn't matter whether you approve with it or not. The bottom line is, the people have spoken, and it's law, so. Commissioner Trace?
Yeah, I'm glad we're going to be planning it, but have we actually had people asking for the permitting? Because I know Pinellas, I know of several people that are already kind of set up, ready to go, so we have people in line already?
Some counties are a little ahead of us. We have had inquiry, but we have had no one actually apply. Just the past few days, I've talked to a couple people, their legal representatives who have said, we'd like to get something going. Said, we don't have a process by which you can apply right now, so they understand that they're just going to have to wait until we have
The
an
way I
ordinance
understand
to
it too, you
move
do have to have a prescription from a doctor, correct?
Yeah.
I mean, it's not just,
You do.
That's correct.
not
And
like, it's not going to be sold at 7-Eleven.
No. I've had a number of people already call me and say,
Maybe
wow,
in the
when can I
parking
start
lot."
growing my own? And that's not, part of this whole thing.
No, I get sinus.
No, doctors have to be qualified, they have to go through training, they have to be registered. There's
Certified,
approximately a little bit less than 200 doctors in the state right now who are actually qualified physicians who can write prescriptions.
So are we kind of considering it like a pharmacy then?
Dispensary.
No, it's a
Dispensary,
dispensary, it's entirely different. This isn't going to be like the drive-up window at, Walgreens and
No.
you get
it's a
your
dispensary.
marijuana. No, you have to go to an actual, they're called medical marijuana treatment centers. There'll be a dispensary where you can go deliver your prescription and receive whatever it is. And no, you can't smoke it. It tends to be either nasal, oral, or ointment.
Thank you.
I've learned more about marijuana than I absolutely want to know, but I can sit here for hours.
Oh, boy, I want to say something.
Be fun.
Commissioner Benak.
Okay, I got a bunch of questions. So we're not preempted from dealing with the land use restrictions on distribution of medical marijuana. Is that correct?
That's a question for me, I assume, and yes, ma'am, it
Yes.
absolutely is correct. We are not preempted in terms of our land use powers to decide the appropriate locations, community character, and compatibility, all the issues that come up under our comprehensive plan and land development code.
Okay. And the purpose of this moratorium is simply, and I see people shaking their head that maybe Fred's not right, doesn't have the law exactly down right, and that's possible. It's a constitutional amendment, and there really isn't law implementing it yet.
Right.
And that is the purview of the legislature to do that. And we need to be making sure that we understand what that is. And the purpose of this 6 months, as I understand it, is to understand what the legislature is going to do with this, make sure that our rules jive. We're not in any way trying to stop it. We're trying to make sure when we implement it at the local level, because we have land use restrictions, that we implement it properly, consistently with the intent of the constitutional amendment. We're not trying to undo a constitutional amendment. We can't do that, but we are trying to make sure that we understand who and how they're regulated, because we do regulate doctors' offices. We regulate them by zoning. We regulate them by permitting.
Right.
So there's going to be regulations, and we just want to make sure that we get it right. After we adopt this moratorium, what will be the process? I know Linda doesn't like that word process, but what will be the process to go forward to have regulations? What will staff do?
Basically, staff will review all of those regulations that come down from the Department of Health. We would propose that there would be public workshops, because obviously, you know, they're interested, people here for and against. We need to get their input. After that, we would prepare with county attorney's office, draft ordinance. That would have to go through notice public hearings before the planning commission and your board. So there's a long process here that we're going to have to go through.
And that will take place in this 6-month moratorium, presumably, correct?
We'll try.
It has to, unless we extend it.
Unless we
We're going
extend
to have
it.
to get it done within that time period.
Okay. So the idea, and, you know, if there's other places like Pinellas County that didn't adopt a moratorium and they've got shops set up, there's nothing that prevents someone from getting their medical marijuana in Pinellas County and utilizing it here. We're not prohibiting that. We're not prohibiting the utilization. We're only prohibiting, for a limited period of time, the sale and distribution, whatever it's called, when it's done for medical purposes.
Yeah.
The prescribing, if you will. That's
Dispensing.
Dispensing is a better word.
Well, basically, what we're doing here is where we would not be allowing, or we would not accept any applications for facilities that process and/or dispense.
Okay, and then I want to ask a question as far as growing. We don't have any regulations regarding growing, but that's all covered by the state laws. I really don't know about growing marijuana.
I'm not sure I'm ready to answer
did in
that, to be
college,
honest
but
with
I don't
you.
remember that.
I think that'll come up in the moratorium.
Exactly.
Yes,
There's
sir.
only 5 growers that have been permitted in the state.
In the state of Florida.
But is that for the medical or is that for the
Sure.
the one
For
before?
everything.
The one that
Charlotte's
was
Web?
already.
For everything.
There are, if I can interject here, there are 6 growers that have now been licensed, and they're licensed for various counties in the state. I don't have the names of them with me, but
That's what I thought.
there's one up in Tallahassee, there's one in Orange, there's one in Tampa, there's one in Miami-Dade, and 2 in another area that it just escapes me at the moment. They are the only organizations that can grow, cultivate marijuana. Joe citizen can't come in here and say, gee, Manatee County, I want to grow marijuana. No, that aspect is totally controlled by the state of Florida. They license, they regulate. Right now, they are not accepting any new applications
Right,
to grow.
I heard.
So I know, and I respect people's private property rights to do what they want, but we're not regulating that, the state is regulating
The
that.
state, most everything that you will see in an ordinance that we bring forward, I mean, probably 3/4 of it will be just state regulation. We can do time, place, manner, distances from churches, schools, those kinds of things, so.
Right.
Okay, thank you.
Okay. Mr. Clegg?
A couple of things. One, this is the first of 2 public hearings. There is no action required today. 2, I think some of the line of questioning here kind of illustrates why there's a feeling we need to put a moratorium in place. The Amendment 2 basically creates a constitutionally authorized activity. And so if somebody comes in and applies for that, and we don't have anything in our code that says where it's appropriate or not appropriate, that doesn't mean we can just say no to it. That's not how land development codes work. What happens is you get into a dialogue with the applicant and the applicant's attorney about what is it like? Is it like a pharmacy? Is it like ag? Is it like something else? And they will take the position that it's like something that maybe is even allowed in a residential district, for all you know. I mean, you could have some pretty bad situations if you don't have an opportunity to adopt some rules to make sure that you've got this addressed in your code in a way that it can go in the correct place. And that's why we really feel like you need a moratorium, so.
I don't have anyone else on the board, so at this time, we're going to open right quick to public comment, keeping in mind, however, that we will recess at noon until 1:30. First is Glenn Jubilina. Mr. Jubilina, if you'd like to come up, you'll have 3 minutes, sir. Well, that's not a point of order, but thank you. I don't have a card, I don't think. Oh, yes, Robert Jordan. Is that one and the same?
Bob and Kathy, yeah.
No? Oh, no, I'm sorry. Yes, I do. What is your name, sir? Okay. All right, it'll be Kathy Jordan, her husband, and then Mr. Puckett. You all each have 3 minutes.
Do we have a hand mic, Quanton? Do you have a hand mic for her? No?
You gotta come over here.
Somebody needs to get it.
Fred,
One of those?
Fred,
just grab her that one.
hand mic.
See if that's live.
There you go.
Yeah.
Hello, County Commissioner.
You would give us your name, and you'll have 3 minutes, please.
My name is.
We can.
My name is. My name is Catherine Jordan. I was president of Florida Cannabis Action Network. I understand that this is in Manatee County, but what you don't understand, what I've been fighting for 20 years, is that cannabis I smoked was grown in Myakka. It was grown from Parish to Sarasota. So these 2 counties are very important. We may have on the soil or in the oil and the water here, we may have something that can stop ALS and stop my disease. Now, I'm not here to argue with anyone. I'm in here to offer services to you for education. I have 3 growers that will meet with you and gratefully explain to you about pesticides, about growing cannabis. Any information you want, I will be happy, and Florida King will be happy to supply you. But the legislators, believe me, in Tallahassee, you know what they say? Do you see anyone from your commission here today? No. but your commissioners can settle this at home. So I believe Cocoa Beach has already done it. They've already said they already have as many cannabis shops as they do ABC liquors. So you're not limited. You just have the power, the legislature, but you can set up where you want dispensaries, how you want them. I've been to Oregon where they only have a 4-inch by 7-inch green cross in the window. It took me 3 times going through the parking lot to find the dispensary. There was nothing but a little green cross. And you do not have to have this done insane. There is nothing to fear. I've been speaking about this for over 20 years, and I have helped people in chronic pain. I have helped people in a lot of issues. And right now, my garden is protected in Manatee County. My husband is protected, but I am not. When I leave my home, I'm open to arrest anytime I light up a cannabis cigarette, and that's not fair.
Thank you.
Thank you, Ms. Jordan.
You all right? Is it my turn?
Yes, sir.
Okay. Bob Jordan, Kathy Jordan's husband. I've also been doing this. We passed out some things that actually was the Braden Herald did a story on us 18 years ago. So this is nothing new to us. First of all, it's not a prescription. The doctor's going to make a recommendation. A prescription has a DEA number. This is still illegal federally, so you'll never get a prescription. It's a recommendation. We don't want, and the reason I'm here is for veterans. 22 veterans a day are committing suicide. In the states where this is legal, okay, the suicide rate's down like, it's down 15%. Okay, I can speak to you from experience because I'm 100% total and permanent disabled Vietnam veteran, okay, with PTSD, and the pharmaceuticals it gave me, I got hooked on, and also made me suicidal. But if I want to go home and use cannabis, and it's just like, it quiets me. There's no hook to it. It's not addicting. There's a lot. The 70 years prior to this has been all propaganda negative. It's not true. 28 states now approve this. But keep in mind, we're not, while I'm here, I don't like the word prohibition. Moratorium. Moratorium got I looked it up on my computer. It says to stop. You know, and so that's what got my attention. If you're going along with the same guidelines as the state, got no problem with that. You know, that's what we want. We fought for years to get to where we are today, and we won. 71% of the people won it. So I would, if you need, or I guess we're some kind of experts, but if we're available, we're making ourselves available to you guys because we don't want California either. Guy staying out with his face painted green, waving a sign, marijuana here, see the. No, California was 96, and they made mistakes. Do this right, and we can really, really have a good thing here. And I can't think of the word, but anyhow, it means if you come from another state, your car is recognized here. That can really be a boon. This is going to be a boon for our community. You're not going to be able, soon you're not going to be able to find a warehouse. Property values go up, everything. So this is a win-win. So the reason I'm here is for veterans, 22 a day committing suicide, and I don't want to see it stop. So if you're going, and I have no problem with the way the state has it set up. Yes, the Board of Health has 3 months, I think it is, and then after the 3 months, it's 9 months. And then if you're working this get out in that timeline, I have no problem with that. But if you try to extend it again over that, every day this goes on, just remember, 22 veterans a day are committing suicide. And that's, if we can look at it that way, because my thing was, if you're going to help a veteran, vote yes on too. So that's my reason for being here, and we're here for your help if or help you any way we can. Thank you.
Thank you, Mr. Jordan.
Thank you.
Dennis Puckett?
Can you hear me now?
Yep.
Okay. My name is Dennis Puckett. I'm a resident of Manatee County in the wonderful state of Florida. I have been sworn. I'm here because I heard that a moratorium was going to be placed on medical cannabis. And I'm here to tell you that there's a lot of people that are suffering like crazy. I'm glad that you said you weren't going to stop it because 71% said that we need this. It's not recreational. It's for people like me. I've been to 5 neurologists, 3 pain clinics, and all kinds of stuff. All they've done is make my body a living hell, and I have no quality of life. If you have a moratorium right now for the person to apply for the application, they have to go through all this stuff. Well, the person has to be a patient of that guy or woman for, I can't remember, it's 90 days or 6 months before he will even recommend it. So the longer you put this off, the longer you're making people suffer. I mean, it's horrible. The pain mill fight that Buchanan started and everything else, I used to have to drive all around town and the whole county just to find my medicine. You know, they wouldn't fill it. And if it's a temporary pharmacist, he wouldn't fill it because he didn't want to take a chance. I've lost my teeth because of dry mouth. I'm on fire from neuropathy. And I'm not asking you to look just at me. There's a lot of people like me like this. I'm not a county patient, and I'm begging you not to put a hard moratorium on this because not only your delay, it's going to cause the delay of the people putting in for an application, and there are no one in Manatee County that's legal that can even authorize this. Sarasota County has 3 from the previous medical cannabis law bills that were passed. And I just beg you to have some whatever.
Thank you, Mr. Puckett. It is a little bit after 12. I'll go with one more, and then we'll come back here at 1:30. Is that the pleasure of the board, or do you want to continue?
How many more signed up?
I have 3, and I don't know, there might be others. I mean, I can only, let's see.
Let's say
We'll
go
judge it.
12:15.
All right, 12:15. Glenn Jubilina?
My name is Glenn Jubilina, citizen, resident of Manatee County, and taxpayer. First of all, let's look at what this does. And every time you delay this, you're denying our vets and people in need, people like Kathy and other vets. So I just want to bring this up. We all know the benefits. The problem that I have is with the zoning. I mean, you want to make sure it doesn't go next to a school or this and that. Put it in the worst case scenario. Let these people start moving forward and opening a facility. If you say, hey, Walgreens sells Oxycontins and Vicodin, and ABC sells 180 proof grain alcohol, all those drugs and alcohol kill people. Where are they zoned? Let the medical marijuana be zoned in the same place. Maybe it's next to a strip joint. Who wants to be next to that place? Put it there. Give them an opportunity to start looking for a place to be. As far as 6 months, can you even do it in 6 months? You talked about an extension. I'm going to put that on the record. The problem with the extension is, first of all, I don't think the board may not get it done in 6 months. That's the problem I have. And then you have people like Dennis continuing to suffer. That's not fair. You need to pass the zoning today and say, okay, we're going to start here, and if we find out this is good, maybe we'll allow it where gas stations go or some other zoning place. But put it in the worst case scenario for right now. The 6 months, I have a problem with that, and let me tell you why I have a problem. Because the desk outside here. I said, where's the permit? Well, it wasn't there. So I get a call yesterday and it said, oh, we have a permit and I'll go down and put it there right now. I said, he says, but it's expired. I said, how'd that happen? So I went down, he said, we only paid $50. So I said, okay, let me do a records request. You pulled a permit in 2015.
Is that on item number?
Well, it's with
16?
the 6 months timeline. I'm trying to do an analogy of 6 months.
Glenn, continue on with talking about
medical marijuana.
the item at hand.
Okay, alls I'm saying is I don't think the county is capable of doing this thing within 6 months based on they couldn't build a desk in 6 months. That's my point. And it cost the taxpayer $200. So give them the worst case scenario. I don't care what you do. Put it next to a strip joint. Put it where alcohol is served. Can't be any worse than Oxycontin or grain alcohol. So give these opportunities because these people cannot wait 6 months. You heard from the medical field. They're ready to move.
Thank you, Glenn. Jamie Canfield? Is Jamie here? No? Okay, Linda Neely.
Linda Neely. Anybody that's going to be a medical provider, as in the Amendment 2, they have to grow the product to create the cannabis oil or however it's going to be used. So when you create this uncertainty, it's, they're saying 6 months and then a possible 3 months and even possibly 12 months. So we don't know. The providers have no certainty. And, I know you don't like analogies to this conversation, but Donald Trump won the presidential election, and nobody was prepared for it. Amendment 2 was not a surprise to you. It was on the ballot 2 years prior, and it came back. And yet you did not see fit to spend our money at all to make any planning ahead of today. I find that kind of disappointing because we lost barely 2 years ago, and this time they passed it at 71%. And so you want to put a moratorium in place that if the Department of Health does jump through all their hoops, and let's say they get done in 60 days, what happens to the people that need the product? It's been taken care of at the health department level, as in the amendment. Do they wait yet on you all? I had a workman's comp injury in 2010, and I'm going to tell you, I can feel for these people because I finally gave up on Western medicine personally because they were going to kill me with the drugs they were giving me, telling them they were going to fix my conditions that I received through my injury. They need a chance. We know that doesn't work. What Western medicine has right now today in their tool bag of drugs and pharmaceuticals isn't helping them. And if you're really that compassionate, then make your moratorium for 90 days. It doesn't have to be 6 months. And put your staff to fixing it for the people. Spend our money in a way that we would like to see it spent. Spend your staff hours getting it done for them. Thank you.
Anyone else from the public like to come forward? Yes, ma'am.
My name is Margaret McCarthy. I'm a resident of Bradenton. And I originally lived in Colorado for 30 years. I voted for our medical marijuana here, and I voted for it there. I left there before it got passed, before it was implemented. But what happened was, it was really interesting, and this is something you need to really think hard about, is I owned a small business, and I would go back and forth. My clients were land developers, and I would go back to service them a couple times a year, and I did my work remotely. I went back 1 year, well, when I left in 2010, they were turning off streetlights. They had turned off the water. They had closed the bathrooms. They turned off the water in the parks. They closed the bathrooms in the park. They took out the trash cans in the park. They cut back all kinds of city services and county services. I went back a couple years later after medical marijuana had passed. My developers, who were they were friends with the Bushes. They were super ultra conservatives. We got up in a homeowners association meeting of 825 households of people, and a lot of people showed up, and everyone was singing the praises of medical marijuana because everything got turned back on, and they built more parks. So you can miss the boat here by putting this moratorium in place, and other counties are going to benefit from what's going to happen, because it is going to happen sooner or later. I don't believe that you haven't thought about this at all. I don't believe that there haven't been any discussions since 2014 when it barely passed by 50-some%, and now it's passed by 70-some%. And I can't believe that you haven't done something. I don't particularly, I'm not a smoker, but I'm looking forward to CBDs. My doctor is waiting for you guys to make the decision so I can get them, because I have multiple problems. And as you know, you don't see this room filled with kids, do you? You don't see the people that are asking for this aren't the kids. We need it. We need compassion. You're a nurse, right? When you get sick, you guys go and get an IV and stick it in your arms and make yourself feel better. Doctors and nurses do that to themselves so that I know it happens. I've seen it happen. Even my doctor talks about that, because it helps so that you can go on and do your job. All I ask for is the right to take something that isn't a addictive pharmaceutical drug that I would like to try. Even the NFL is talking about doing this. Don't put a moratorium on our community. Let's get this started. I'm sure you can figure out how to make this work in a shorter time frame. Thank you.
Is there anyone else from the public that would like to come forward?
Good afternoon. My name is Rita Chamberlain. I'm with Drug Free Manatee. I'm also a resident of Manatee County. I don't mean to delay anybody's lunch. We all been here for a long time this morning. But I will point out a couple of things based on comments made previously. One, all we're asking for is time to do it right. I don't think anyone has a problem with trying to do something right. So that is what we're asking for. Consideration, process, and value added to the discussion that you have. The other point I would like to make is that medical marijuana is available now. There is a compassionate use registry at the state. You can get it through the Department of Health. There are physicians already making recommendations. It is available. It's available in pill form. It has been available for a decade. In this state, it has been available from 2014. We even have the right to try for experimental versions. So the fact that you're putting in a moratorium is not delaying it for people who actually really need it, who are willing to go through the process that we have already put in place through the legislature. We support a 180-day moratorium because we understand this is passed. We know this is happening, but we need to be very clear about the ramifications. Saying that it's going to bring all kinds of largesse into our community is not an excuse for not doing it right. I commend your willingness to consider this, and you have our full support and use of resources. We will provide you any information that you need and be a part of this continuing discussion. Thank you very much.
Thank you. Anyone else from the public?
Commissioners, Sharon Kramer, Director of Drug Free Manatee and a resident of Manatee County. has been stated, Drug-Free Manatee strongly supports the 180-day moratorium on new medical marijuana dispensaries. It is a new industry in this state where cities and counties are not prepared. We applaud your due diligence in doing it correctly. It is illegal federally. It is therefore a cash business, which increases crime. It has lots of potential for unintended consequences. So on behalf of the coalition, we encourage you to do the 180-day moratorium, do it correctly, and protect the citizens of Manatee County. Thank you.
Thank you. Anyone else in the public want to come forward? Not seeing anyone, we will close public comment. Commissioner Benak.
Yeah, I thank you for bringing that up because we did have attached the 2016 Florida statutes that the Florida Senate, what was adopted, the compassionate use of low THC in medical cannabis. So there is a process. I understand it isn't as convenient and it prohibits smoking, the existing regulation. So this new regulation will, as I understand it, will allow smoking. But maybe I got that wrong. I got some shaking their heads yes, some shaking their heads no. So I don't know what the answer is. But I just want to say I appreciate also everyone coming forward and being willing to offer their services as we develop these regulations because we got to delve into the law and figure it out and get it right, as was stated. So I do appreciate that. But there is a process that did get adopted this past year to allow for medical marijuana compassionate use in certain circumstances. Yeah, and it doesn't say that. And you all have a copy of the law as it was adopted. So thank you for clarifying that.
I'm going to move in here. I'm actually next on the board. I think with what Commissioner Benak just said, it shows the necessity of having this moratorium. We have to figure out and understand what the state law or what the state is going to mandate to us that we do. So we really need to do this. I realize there might be other counties that's moved a little bit quicker, but I do agree that we need to make sure that we get this right. This is not something to play around with. This is going to affect the quality of life that we know in many different ways, depending on who you are. So we've got to make sure, and we owe it to the community. That's why we're here. That's what we're supposed to do, and that's what we need to do. I can assure the public we will do it in a timely fashion, but we will also make sure that we do it in a way that we feel is best for all the residents of our county. That being said, I'm a little bit confused. Nicole, maybe you can help me on this. In looking, this is just the first of 2 required public hearings. We have another one that's scheduled, December the 13th?
Correct.
All right, do we need to go ahead and make a motion to have it at the regular meeting time? I'm a little confused on what I'm reading here.
There is a motion here that action does need to be taken on to hold the second public hearing between the hours of 9 and 5 and not after 5 p.m. Correct. We discussed that at the briefings.
Okay, well, I don't recall that, but I mean, it's probably that we did. So, who said that? Thank you. Do I have a second? We have a motion by Commissioner Whitmore, second by Commissioner DeSabatino. And Madam Clerk, can you tell us the motion, please, so we can make sure everybody understands?
The motion that's listed in the staff report states to hold the second public hearing on ordinance 16-49, but I have after 5 p.m.
No,
you're waiving the requirement to hold it after 5
right.
p.m.
The motion is to hold it during
But
the
the
regular.
agenda memorandum says after 5 p.m.
What?
To hold the second.
Right, it says I'm
Waiving, okay.
move to waive the
At the
requirement.
waiving part, yeah, okay.
Okay. Now, am I to understand that this motion, we will need 5 votes to do
Correct.
this?
Why? Well, I don't even want to know.
Requires majority to make this change.
All right, so that being said, with everyone realizing that, all in favor of the motion to hold the next hearing on this December 13th at our regular meeting, say aye.
Aye.
Opposing the motion, say nay. All right, it is approved then 6-0.
Okay.
All right, we are going to go ahead at this point and recess. We will come back at 1:30 for commissioner comments. Is there anything else on the agenda, Nicole?
Also for the motion to continue item
We have,
17.
item number 17.
Oh, right.
We can do that after.
Okay, we'll do that after lunch. Thank you. We are recessed.
Isn't that, they are
That's the
both
one.
on that board,
Yeah.
yeah.
My husband's always,
That's one.
Yeah, I work on mine all day.
All right, we'll go ahead and get back in the meeting. We are actually on item number 17, the Manatee County Pain Management Clinic Registration Ordinance. Nicole?
That describes it, Pain Manatee. Pain Management Clinic Registration Ordinance 1644, and that's a revised motion to continue the public hearing to January 5th, 2017.
All right, I'm gonna go ahead, well, Commissioner Benak, did you have?
You know, and this is interesting because I think we all just received an email from Catherine Edwards saying that she couldn't be here, but she was asking why this item, as well as the medical marijuana, were on this land use agenda when they had nothing to do with land use. But the reality is they both have everything to do with land use.
Yes, they do.
Because the issues that are being regulated are land use issues. So in case Catherine was watching, I thought I'd go ahead and say that, since she just sent us all an email relative to why we would have these things on a land use meeting. It's because they're relevant to land use, so.
All right, I'm going to go ahead at this time, too, and open this to public comment. Anyone like to come forward and speak on this issue? I don't think so. Claire? All right, we'll close public comment. We have a motion that we need to make to continue this item, and
so moved.
Second.
we have a motion by Commissioner DeSabatino, a second by Commissioner, my mind just went blank.
Trace.
Trace. I apologize.
That's-
All in favor, say aye.
Aye.
All opposed, nay. All right, it is approved unanimously to be continued until January the 5th. At this point, we're going to go down to commissioner comments. Why don't we start with you, Commissioner Trace? Anything that you'd like to discuss today?
No, but not necessarily discuss, but I would like to say thank you all for making it so easy and helpful, and would definitely ask you all to tell me to, like throw something at me if I start to put the old foot in the mouth too seriously. So I'd like to thank you very much for making this a nice, semi-easy one for the first time.
Yeah, it could have been much worse.
I don't know if we had anything to do with it.
Yeah. Commissioner Benek?
I don't have anything at this time.
All right. We'll start down at the other end then. Commissioner Whitmore?
Oh, I forgot. I was going to say something, so maybe while you guys are talking, I can remember. I was going to write it down yesterday and I forgot.
Well, what happened at lunch?
Everybody had.
Brain dead, now
See,
she
you needed
is.
to have breakfast for dinner.
I was going to
Or
say, it
lunch,
must have
like
been
I
the
did,
food
yeah.
everybody ate. Go ahead.
What we talked about this morning, workshops on camera.
Mm.
Does anybody want to talk about that now, or, because that would have to be like a budgeted item for next year, or a modification to the budget, because that would be more money to televise them either upstairs or bring meetings back down here, but it would still mean more money for filming.
I'm glad you brought that up. I will say that, I would be in favor of doing that. I have been trying to get that done this year. I mentioned it when I first took over as chair. I think to be as transparent as we possibly can for the public, I think it's real important. And I like too that, it would be a way that we could, the commissioners ourselves could go back and look at it and refresh our memories. Because I can't tell you how many times in this last year that I have had to get audio from our workshops. And she can testify to that. Many times I try to get the audios from different workshops. So I would love to see that televised as well.
So how do we go about that?
Commissioner Whitmore, you're on the board.
Yeah, I still don't support it, and the reason why is because, and the majority of the commission hasn't, and that's why it hasn't been brought yet, is, if there's certain issues like what we discussed today, that's no problem. But most of the time when we're at our work sessions, it's an informal setting, and you can sit down and cuss and discuss, like John used to say. When you're here, you can ask anybody, and it's been brought up 100 times. It's more formal. The person has to come up at the dais and talk to us. We're not all sitting around a table at the same time and trying to, and mainly the work sessions are education for us and issues that are going to be coming up. But with the one that we were talking about today, I totally agree on that one. I forgot what it was. But in the past, you know, the whole purpose, like we're going to have a work session soon on EMS billing. You know, that's mainly, we've asked to because we wanted to learn about it. The public's totally welcome to come. It's just when it's not around the table, pulling up your sleeves and all talking and learning. You know, when we have the work sessions, we may have 5 or 6 people from staff across from us like they are down here. It's just, you lose that formality, but I'll probably lose this one, but I still like it the way that we've had it for that only reason. And if there's ones that need to come this, you know, up here and have it on TV and live, I'm fine with it.
Commissioner Benak.
Yeah, in terms of, there's certainly been some issues that I think should have been on television. And so I do think it is kind of a, not everything needs to be televised as far as a work session. And I am not so sure I want to make a decision today.
No.
I would like to hear from staff, you know, as to why it works better for them to have it on the 4th floor if it does. But certainly, I think if there's an issue that's on a work session and you think it needs to be televised, I think you all should say, we need to have it down here.
Yep.
And we need to discuss it and vote on that happening, because I think there are things that should be on TV. Not sure that everything has to be on televised, every work session, but I think a lot of them, there probably are issues where it needs to be discussed on TV.
Yeah, you know, the problem is that when you get an audio, I mean, the public, yes, can be there, absolutely, but not everyone can take off from work to be there.
Sure.
So, and a lot of times there are topics, I mean, this is where we discuss different things that we end up bringing here before this board for us to vote on. So we go over a lot of very important issues. I mean, there might be a few where it doesn't matter, but I think, you know, with a new board now coming on board, we need to be as transparent as possible. And a lot of times, and I know I've had this happen in some of the audios that, you know, I've gotten, sometimes you can't hear everything clearly that is said, and you're not always sure who says it either. And that's also an issue. So for me, it would make, I think, my job easier to have it filmed. You know, and I don't want to vote on it today. I mean, I think we should probably talk to staff and find out what the cost would be and so forth to look at it. And it might even be something that we'll have to wait on until we can get it in the budget. But it is something, I think, as far as moving the county forward and trying to be as transparent as possible, which is my gig this year, I'd like to see it. Commissioner DiSabatino.
One of the reasons why I brought this up, and they don't have to be televised down here, they can be upstairs, they televise other areas. It's, again, there's a lot of times where we discuss a lot of items that will be coming before us. And then when it gets here, and then the public hasn't had that information, that knowledge, it comes down before us, and we all know it's been discussed, so we all have that, and it's just like, oh yeah, let's just vote on that, and they have no idea what went on, you know, making the sausage, so to speak. So I just think that we could try it. I brought that up before, do a couple-month trial to see if it's working and to see if the public likes it or not. But I know I was up in St. Pete and I was just surfing channels and I was watching their the city commission meeting, and it was a workshop. And it was just real informal, and they were all in jeans and whatever, and but it was good to see, you know, the more casual interaction. So I just think it's worth a try.
Commissioner Whitmore.
There isn't any city commission work sessions in Manatee County that are televised. There are some regular, and I think that's Bradenton, because I go to all the city meetings in Lombok Key. And not all of them, and mainly the regular formal ones, the regular meetings are usually off. So St. Pete may be doing it a little different, but again, a lot of the stuff we do, and I'm thinking of the budget, going through a 1,000-page budget with 10 or 15 people across from us, going through it and having a discussion, instead of them having to be recognized, well, they're recognized by the chair, but it's a lot more casual and less formal. So I would just please request that we talk to the staff, because they've told us their concerns many times, and we've actually always gone back to having them, upstairs on the 4th. We're still going to have them at the same time in the daytime, so it's, if people can't come, they can watch it on TV, or they can request for public records to get what was at the work session, like the chair has done. So we're not hiding anything. The press is there. It's duly noticed, and maybe 1 or 2 people show if it pertains to them, and that's it. So, and it is a time that we can also, we don't dress up, and we can be casual, and when you're here, you don't. You can come in jeans or whatever, and you don't usually when you're down here. So it helps us in a working atmosphere too for work sessions. The legislative action is always taken at the regular meeting. So it's just it's mainly a big educational process for me. And I know we've been trying to do this for years, and it hasn't passed the muster, and I think when we talk to staff, and maybe we'll just talk about it again, but I still support, again, specific ones, requesting them, and we'll have them down here, and we could find out budgeting how much that would cost, like 10 or 15 of them a year, who knows? But the rest that are minuscule, we need to have them upstairs still, in my opinion.
All right, I'm going to address that. I'm on the board. Number one, I'm sorry, Commissioner Whitmore, I do agree with you in some ways, but a couple of things that do stand out to me on this issue. Number one, the way things might have been in the past in this county doesn't mean that that's how it needs to remain.
Last week.
I know.
It's
I'm
not
just
the
saying.
past. I'm talking about
I
this year.
didn't interrupt you, Commissioner Whitmore,
Well,
so how about
happened.
letting me finish?
It happened.
I can also tell you that there have been things in the workshops that have been said, and then I would try to go back and get the audio to make sure I heard it correctly, and I couldn't tell from the audio. So, and another thing to point out too, and you talk about the budget, I think that's a very good thing to talk about and think about. When I was running for reelection here recently, what I kept hearing and what was trying to be said was that we don't look at the budget. We don't know how to read a budget. We don't know how to do things. And part of that could be said only because there was no film of us sitting there going through the budget line by line. And yes, yes, it is. The reporters are in the room, but they don't report it. Now, not all. But some don't. And it's a political issue. If it's on film and it's obvious that it's taking place, there's no way to be able to argue that point. And I know it wasn't just me that had that thrown at him in this past election. So again, for me, it's really a matter of trying to be as open and as transparent as possible. If the citizens are feeling that we don't look at the budget and we don't pay attention, then let's show that we do. And the only way we can do things along that line is if they can see us doing it. So that's why I'm in support. I think, it's been set up here, and I agree that, yes, not all workshops are, major and need to be, televised. I understand, but, if it helps on some of the bigger issues at hand, I think it's very important. So, I'm hoping that we can take the new board here and try to get as transparent on things and work with the citizens as much as we possibly can so that they can have a better understanding of what we go through and what goes on. That's my only point in supporting it. Do you have anything else? Because I'm the last one on the board on that issue.
No, I'm good.
Commissioner Johnson,
Yes.
let's hear from you. What do you have, sir?
I have very little to say, other than, again, the last 2 weeks has been a whirlwind time in my life, and I've enjoyed meeting all of you all up here on the board, and obviously the staff has been great as far as trying to indoctrinate me into all the goings-on in the building here in the county, and I'm very thankful for all that. I hope we can continue a very strong working relationship, both up here and outside these doors as we go forward over the next several years. And that's about all I've got for today.
All right, well, I guess I'm the last one here. Welcome again to our new commissioners. It's nice. We will certainly miss Commissioner Bussell and Commissioner Chappie, there is no doubt. But, you know, we are blessed to have the two of you with us, and you will both, I'm sure, do a great job for your districts and for Manatee County as a whole. So from my standpoint, I'm glad you're here. Look forward to working with you. And that is something I would like to see from the commission is a better working relationship. We're not all going to agree on everything that takes place. We're not supposed to. That's why there's 7 of us. But you know, we still need to be civil and respect, and the key word there is respect. So I'm hoping, as I said this time last year, you know, I'm gonna repeat it. I'm hoping that here on out that we can treat each other with more respect and make the decisions that we need to make, because it's going to be a big year. There's a lot of big decisions that are going to take place this year, and we're going to have to stand together to get it all done and look out for what's best for the county. So, Commissioner Benak.
Yeah, I did forget something. I had forwarded, because this is the only time we can talk about stuff like this, I had forwarded you all a copy of a Facebook message that I received, and I just want to make sure y'all got it, because I know some of you don't accept forwarded messages from a commissioner, and I sent it all. I just want to make sure y'all got it, because it is pertinent to something that is going to come up before us.
I got it.
And it was dated 11/28 by David Craig. I think it was on the Parish Network or something. It was Facebook message. Parish Parent Network. I don't know all of those networks, but it was an interesting email.
Yes, it was.
So I just want to make sure you all got that.
What was it about?
It's
We get
about-
hundreds of emails.
When did you send it?
I forwarded it on
Days
Monday.
ago.
Monday.
So what was it?
It says, message received and forwarded to me on Facebook, 11/18/17, please forward FYI only. I sent it to Sherry, and I believe she sent it to all of you.
She did.
But honestly, I can't remember, because some people opt out of getting those forward all messages. So I don't know whether y'all got it, but it's something that I think is relevant to a topic that's going to be coming before us, that is the pool. So I just want to make sure you all got it.
Yeah.
Quite frankly, it was accusing me of doing all kinds of things, which I thought was
Oh, that
interesting.
way.
Oh, yeah, now you
Now I remember.
remember it. And I don't have any way to respond to this person. The person who sent me the email, I said, please give him my email address. I'd love to, correspond directly with this person. But because I'm not on the Parish
Parent
Network. I'm not on that network, so.
Yeah.
Anyways.
I didn't
so,
see it.
I
Go
just
ahead.
wanted you all to see it, just to understand how some people perceive things that are going on in this community.
It's not all
So-
one way.
And
No.
it is an issue that's going to come back before this board, so this is the only time we can talk about it. So I hope you all will take a look at that email and recognize that some people in Parish have concerns. So,
Commissioner Smith, is it a
He's at a
fact
fact
meeting?
meeting.
Okay.
And is it in Orlando, right, I think?
Yeah, we're going tomorrow, Priscilla and I, for the Gulf Coast Consortium BP oil spill thing. So we're driving up tomorrow morning.
what's going on with that? Can you tell us? Is anything going on?
Yeah, well, tomorrow, we're hearing from all 23 counties on the plans on how they plan, and their wish list and their plans on how they want to spend the money that they're going to be allocated. Charlie is coming up before a work session to talk to us about it. I think it's scheduled to keep everybody abreast of what's going on. But if we wouldn't have been at that one within the last 6 or 7 months, I think Vanessa was there, maybe it was
Amelia
last year.
Island.
Yeah,
Yeah.
we happened to,
That was a great
they were gonna
meeting.
take the money, Pinellas County Commissioner and the Executive Board were gonna take the money and they decided that they wanted to spend the money on regional projects. When I'm sitting here and I'm looking at all the county commissioners squirming in their chairs, and, because we're tasked to, it affected all of us in the state of Florida, we're tasked to bring back the money for our county. So, it was all ready to be voted on, and I just raised my hand and I said, I don't think that's what all you're seeing from all these commissioners here. I think we should distribute the money evenly. And all the commissioners, raised their hand, supported it, and actually, one of the commissioners, she's not on the executive board anymore, because I think they got very upset about it. But it's only fair that each county be able to do it, and Manatee County, Charlie's gonna be meeting with you guys. He's got a plan that, it's environmental, and we've all given that direction. It was an environmental disaster, and he has projects within the county that he's gonna be bringing before the commission. And he's gonna present to them, and it's more than what we're allocated, for sure. We're allocated like 13 or 14 million, and his project list is like in the 50s, you know how that always goes. So he has a list that he's already submitted to them, and I'm just gonna go to make sure that they don't try to do anything with it. And we hold our seat. So we gotta listen to all 23 counties. They get 5 minutes each on their plan. I'm gonna have to tell Charlie to talk fast. And that's what's happening tomorrow.
On that note, the Amelia Island meeting that Commissioner Whitmore is referring to, I was up there for a FAC conference, but I knew that meeting was going on, so I went and sit down and watched it. It was very interesting, and Carol did a great job that day.
There's some strong personalities all over the state of Florida that are, and you just have to be right there with them or you're gonna lose out.
So also, I just wanted to commend Commissioner Smith for getting certified, local government certification, and then attending all these meetings in our behalf. So he's spending a lot of time.
Yeah, Jane Von Haman used to do that, and she got certified.
Well, we've had a great first meeting. The next meeting is December the 13th. That will be a huge meeting. It'll be our first regular meeting with our new board. At that meeting, we will be voting on several important items that will affect this coming year and after. So look forward to that coming up, and have a great week, and we'll all get together next time.
Okay.
Thank you. Meeting is adjourned.
So what was that email?